For the complainant, my lord,
One second.
that
Serial
accused
number
have violated the
one
single
sec-
judge's order, my lord.
1 second. Serial number 1 to 25, 24.
24.
We grant 3 weeks.
Hello, your lordships kindly, serial number 10, my lord, I appeal to the appellant. May I request it on the 15th of March?
You want more than 3 weeks.
My lord, I want less than 3 weeks. May I request?
Less than, you can remove within less than 3 weeks. Generally, we are granting 3 weeks. You can remove and get it listed. Once it is
Please
listed,
request For a date, my lord, on 15th of March.
but you remove the office of,
Very well, very.
then mention.
My lord, serial-
Number 3, and for the appellant. Typical matters, these laws have been disposed of by a coordinate bench.
Serial number 3 on the board.
Yes,
Yes.
we endeavor, that is, respectfully, our decision this year, permitted to pass it on. My lords have been, they dismiss the appeal. My only endeavor is, that direction be issued, please, not to non single judge.
Then let it be called out. Wait.
Serial
My
number.
lord, serial number 1, my lord. Serial number 1.
One by one. Yes, Mr.
Memo for posting, my lord. Fresh matter.
It will be listed once you remove the office objection.
Please.
Yes.
My lord, memo for posting, I've removed the
It
office.
will be posted once you remove the office objection.
Fresh matter.
Once remove the office objection.
I have removed the office.
Memo will create, on the contrary, the difficult situation. We are flooding us with the memos.
Much obliged.
We will be posting once it is cleared with office
I
objection.
have cleared it on Saturday, my lord. That is why.
Once you remove and within 5 days. Yes, yes, madam.
My lord, seal number 23, my lord, we have already complied with the office subsection. The IA for suspension has been already refused. That we have complied it, my lord. It may be taken up along with the seal number 74, my lord. It is arising out of the same judgment.
74. We'll take up.
Translated. Obliged.
Memo for posting, my lord. The single judge's order has been violated by the accused, my lord. It may be taken and
Remove the office objection.
removed, my lord.
Remove, then get it listed within 1 week.
Please, my lord.
Serial number
Same, my
53, my lord.
One second. Provided it is, Mr. Counsel,
Madam.
Mr. Counsel, provided it is removed.
Removed, my lord.
Yes, all.
Serial number 53, my lords. I'm seeking to withdraw the
One
petition.
by one. In line, yes.
Serial number 53, I appear for the petitioner. I'm seeking to withdraw the petition,
53.
please. I'm filing a memo to that effect.
Learned advocate, Miss.
Amanda Chakravarti.
So seeks permission to withdraw the bill number 53.
Please, my lords.
50
53, serial number 53 for the petition.
6, that is writ petition 32306 of 15. Learned advocate, Miss so and so, appearing for learned advocate, Mr. Ajesh Kumar.
Please, my lords. I appear on behalf of Ajay.
Seeks permission to withdraw the present writ petition upon the instructions of the petitioner. She submits the memo indicating the instruction to withdraw. Full stop. Writ petition is dismissed as withdrawn.
Great.
My lord, serial number 1, my lord. You press 2 weeks time, my lord.
Serial number
1, my lord.
1.
Yes, 3 weeks already granted.
Granted.
My lord, memo is for posting, my lord. Memo for posting, my lord. Our respondents have suffered a loss, my lord, by which the government has acquired the land, and a single learned judge has.
Remove the office objection.
No, there is no objection, sir. It may be posted for the orders, and because the response are not been served by the state government.
Then it will be posted. What is the difficulty?
On 5th of March, my lord. It may be posted, my lord, for order because the response of the backward communities, they are suffering a loss, my lord.
If you are already cured the defect, it will come within.
It will
5
come
days.
within 5 days.
My lord,
Within 15 days.
My lord, serial number 14, my lords. Certain translation copy has to be filed, my lords. My lords, may kindly grant 3 weeks time, my lords.
It's already
Granted,
granted. All 1
3
to
weeks.
24 serial are 3 weeks. Don't
Okay.
make submission.
Yes.
Urgent.
Where accused was issued warrant, but she was not aware of it. And then date showed it says 2/4/2024. So that means he could not appear. This one was used to issue warrant. Recalling of warrant.
Are you complying with?
There is no direction to be, I already sold the property way back in the 2019. The petition was up there 2021.
When the warrant was issued?
On on 1/3/20, on 1/3, the 1st of March.
Get it listed. Day after. Day after.
But it's much okay. There's no more fresh matter.
That will be listed once you remove the office.
My lord, this,
It will be listed, madam, once you remove the office. Don't interject your own process of removal of office by submitting memo every time. You first remove the office option, then it will be listed.
my lord,
No acceptance of memo.
my lord, my memo to be,
Contempt for, ready for admission, complete all the office objection, my lord, ready for admission.
Then
come
it
automatically.
will
sir.
come
My
automatically.
lord, it is not 23 matter, my lord. Not it for fresh matter is not it leaked.
ಸಾಹೇಬ್ರು
My lord,
ಹೇಳ್ತಾ ಇದ್ದಾರೆ,
One,
ಬರುತ್ತೆ
6
ಅಂತ.
months back I have complained without,
Wait for a week.
my lord, any day, my lord's convenient.
wait
my
for
lord.
a
At least for admission, my lord,
Wait
fresh
for,
matter, my lord.
wait
Memo-
for a week, wait for a week.
ಬರುತ್ತೆ
Yes,
5 days ಅಲ್ಲಿ ಬರುತ್ತೆ ಹೋಗಿ.
ಇಲ್ಲ,
Instructions
memo
ಇದೆ
ಕೊಡಿ ಅಂತ.
ಆಫೀಸ್ಗೆ, ಆಫೀಸ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ. There is an instruction to the office to post all the matters within 5 days.
Please.
my lord,
Serial number
my memo-
87, my lords. I request
Eight.
for a week's time, my lords.
what do you want?
Time, my lords. I am for the respondent council.
87.
87, my
For
lords.
the appellant in this,
Final hearing.
Mr. Manu,
Yes, my lords.
87.
all right. 3 weeks,
Obliged, my lords.
3 weeks.
Lords, memo for posting matters. It's a land acquisition matter.
One by one, one by one.
If the respondent authorities disperse the amount to the respondent number 5, my writ appeal will become infructuous. So, ma'am, tomorrow morning.
How it will become infructuous?
My lord,
How it will become
for
infructuous?
the learned single judge order, my lords, the amount should be dispersed to the respondent number 5. If the amount is dispersed to them, my writ appeal will become infructuous.
12th.
Matter may be listed tomorrow.
12th.
my lord, my
lord,
memo,
tomorrow
One by one.
My-
Yes,
my lord,
madam, you
my-
want to mention?
Adjournment, your lordship. Your
Which-
lordship, serial number 63 and 77. We understand it's preliminary hearing matter. The lordship may not be comfortable giving adjournment, but we are still to receive instructions from board, your lordship.
63 and 77.
Yes, your lordship.
My lords, in 63, I pay for the petitioners.
Serial number 77.
Madam, one minute, one by one, one by one.
Wait.
Other side, other.
Other side in those 63, my lords.
So,
Certain matters, my lords.
They are all
poor
moving the
systems should
memo.
not
Why
be
are you
taken.
seeking adjournment in the middle? Please allow them to complete the memo. Then you make your submission for adjournment. Please have patience.
my lord, my memo to be taken, my lord. I was stated in read petition, I am representing for the response, my lord. The response has suffered a loss, my lord, by which the government has acquired the land of there. In this view, they are suffering loss because they are, the single learned judge has passed an order. That order has been stayed by this, in this appeal, my lord. And here the response are not been served by the appellants.
it will
And it may be posted for the orders, my lord.
not listed.
Not listed, my lord. It may be posted for orders because the honorable court has been ordered. Or it may be taken steps, you have taken steps, my lord, by the appellants.
Within 3 weeks.
You are for
My lord,
respondent.
Yeah, for a response 1 to 4.
Very-
Petitioner has to move, not you.
They have taken steps because they are suffering loss because they have not taken any steps, my lord. Or compensation, they are not paid or they are not allotted land, my lord.
No urgency, let it come.
Let it come within 3-4 weeks.
Okay.
My lord, memo for posting, my lord, we have challenged the proceedings before the KA team, my lord. The matter is listed on 6/3, my lords. Therefore, the matter may kindly be, the writ appeal may kindly be listed tomorrow. ma'am.
The
Otherwise,
matter
my
is-
writ appeal would stay infructuous, ma'am.
The case is pending before CAT.
Before the appellate tribunal, Karnataka appellate tribunal.
So why you are here?
My lord, we have challenged the impleading application, my lord.
Impleading it.
Impleading.
You seek time there and within 4 weeks.
My lord, kindly, maybe, otherwise my writ appeal will be infructuous, ma'am.
Why?
Because the matter is posted on 6/3, my lord,
12th.
For what?
for impleading of the application itself, for carrying out the amendment, my
The
lord.
urgency.
No, for carrying out the amendment, my lords.
Let them do, nothing will happen.
No, we are the appellants in the honorable tribunal also. Before the tribunal also, we are the appellants. my lord.
New matter, it will come on 5th day if you are cured the defects.
Yes.
My lord, connected matter is also is posted tomorrow, my lord, on 5/3, my lord. Kindly, it may be posted, my lord.
How many writs are filed? Writ appeals?
Three writ appeals have been filed, my lord.
Today also there is some impleadment.
My lord.
Today also some matter is posted, similar matter,
No, my lord, on
Tomorrow.
6th, my lord. Therefore,
before this court.
no, my lord.
No.
My lord, that is the impeding application before the land tribunal, which is before.
Yes.
Kindly it may be posted tomorrow, madam.
13th.
Kindly my memo should, may be accepted.
No, memo will not be accepted, Mr. Agle ಹೇಳಿದ್ವಿ, don't disturb me in the middle. ನಿಮ್ದು ಆಯ್ತು,
Yes,
ಮುಗೀತು.
madam. Client rejected, it can wait.
It will come in the regular case, please cure all the defects. It will come within 5 days. Then
It will come then,
It
it
will-
will be posted.
Milord's serial number?
Just a minute.
Will we take one?
3 weeks, madam, it is given 3 weeks. You comply it and then move, yes.
You are free to comply with earlier. Do it tomorrow, today itself, listed. But we have generally granted 3 weeks, madam. So there is no point in.
Even though we have granted 3 weeks time, if all the defects are cured, it will come on 5th day. Don't worry, it will come on 5th day, madam.
Contempt, my lord. I have completed all the applications.
It will come on 5th day.
Urgency.
What is the urgency?
The respondent undertook that he is not obstructing my road, use of road. But after disposal of the petition, he dumped the 2 lorries of muds in the road, and there are 3 school children now, they are going to school. It's very difficult to approach the school.
Chalo.
Lordship, 18 January we filed the matter and objections also has complied, Lordship.
Then
for
it
memo
will-
proposal.
Come on 5th day, Mr. Thai.
Listed.
18 January we have.
It will come now.
Obliged.
Instruction has already given, Lordship has
I'll
directed
not
the
trouble this
office.
court for this.
My lords, kindly, my lords. Serial number 3, please, my lords. Earlier appeal, please, my lords.
Allow
On similar
3.
grounds, please, my lords,
You-
has been dismissed. My only endeavor, please, my lords.
All mentioning is over.
My lord, serial number 86, final hearing matter, my lord, my request for 3 weeks time, my lord,
All right.
serial number
Right.
86.
Yes, madam. One by one. Yes, madam.
Your lordship, serial number 63 and 77. Preliminary hearing matter, but we are yet to receive instructions from board, pollution control board. It may kindly be adjourned, your lordship.
Right.
My lord, 63, my lords, I am appearing for petitioner, my lords, a exorbitant amount to the tune of 5 crores on a small industry.
Let it be called out. Let it.
We'll,
Not
no,
to-
press, we'll
Let
take,
it be-
Pursue steps like.
we'll not
We'll
take.
consider the request of both the sides when it is called out.
In
Wait
serial
for
number
5
seven-
minutes.
Wait till your turn comes. Yes,
Serial
yes,
number
madam.
77, my lord. In serial number 77, kindly extend the interim order till next date.
We are not taking.
You're
the
not
matter,
granting
we
time.
wait.
Taken when they.
Not granting time right now. Let us,
Serial number 47, my lord. for that
yes,
one.
yes,
Some time for that.
47.
47. And 81 also, my lord.
Alla hearing on again.
34 April.
And 81 also, my lord. 81,
81 also.
yes, my lord.
All.
Lord,
4 weeks.
serial number
Much
40,
obliged.
serial number
40,
44, my lord,
44.
for the petitioner.
Yes.
2 weeks' time may kindly be given, my lord. I have to receive some instructions from the petitioner. He is himself not well. Grateful.
Some defects are there.
Kindly, my lords, before the
Please,
learned
madam.
single
What
judge.
in Yashwant Chennai?
May I only make submission on serial number 3? Identical matter has been dismissed, my lords. My only endeavor is, I only one submission to make. My lords, section 217A, please, my lords, and section 89A of the BWSS Act, please, my lords, has been challenged. Under which, please, my lords, 2 provisions, my lords, we raise a demand. Now, my lords, the main matter, please, my lords, is reserved for judgment on 28/3/2023, please, my lords. Now, the further writ petitions are filed, interim orders are passed,
You are for appellant.
please, my lords. And when interim orders are passed, please, my lords, now what happens is, contempt is also initiated against us, please, my lords, based on the interim order. And the main matter is not disposed of, please, my lords. It is, my lords, pending, my lords, for pronouncement of judgments from 28/3/2023, my lords.
We are not concerned with pronouncement of
My lord,
judgment.
my
It is
only
anything-
submission is, my lords, if a direction could be issued, please, my lord, that it would be speeded up, my lords, it would be disposed of one way or the other. My lords, we will know our fate, please, my lords. Otherwise, please, my lords, it becomes very difficult, my lords, because we have statutory duties to perform, please, my lords, under the Act. Section 15, my lords, provide, my lords, for a statutory duty. And the coordinate bench is already upheld, please, my lord, the virus.
Which is the order that challenge in this
My lord, the order under challenge is the interim order passed, please, my lords.
page 15?
Please, my lord. Yes, my
It is
lord.
only except,
18.
it is
18.
only regarding notice issued, nothing more.
No, my lord, the order stays, please, my lord, the imposition of pro rata and the disably vast charges.
Interim order as in writ petition 17084. That is what is happening to that petition?
No, that main matter is my lords, reserved for judgment, please, my lords.
Payment of pro rata. They can go and seek modification before the next. Seek modification before the honorable.
Lord learned,
My only submission is, let the one direction, please, not that the main matter be disposed of, because it is pending for judgment, my lords, for 1 year.
our learned advocate, Mr. So and so, the appellant board, full stop, the present writ appeal is directed against order of learned single judge dated 26th June 23. Full stop. The order makes it evident that it is an interim order and the main writ petition is at large before learned single judge on merits. Full stops. Since the rights of the parties, any of the parties, rights of the either parties are not finally crystallized and the issues involved would be dealt with by learned single judge in the proceedings of the writ petition, this court does not see any ground to entertain the present appeal against interim order. Accordingly, it is dismissed. It will be open for learned, to be open for the appellant to request learned single judge for expeditious hearing of the appeal, which shall be dealt with by learned single judge, depending upon his own calendar.
No, my lords, it is reserved for judgment. The matter is reserved for judgment.
Then where is the question? We
But
can't
the
say, anything.
judgment is not promised.
Then we
my lords.
can't say anything, that last line to,
Here, my lords, for 1 year.
last
my
time,
lords.
last time to be taken out. Yes, dismissed on the ground that interim. We can't say anything about the order being reserved.
My only,
That's right.
because in the contempt has been raised against me, please. That's the issue.
It is learned single is prerogative. Yes. Yes. But,
My lord, serial number 24 has also been adjourned by 3 weeks. Much.
You are for applying petitioner.
I was for the petitioner in serial number 24. my lords.
24 is that,
24 is already urgent, 3 weeks. 25.
My lord, I pray
And
for.
for the respondent number
Lord.
3 and 4. We already filed the objection.
My lord, my office, my objections have been returned with office objections, my lord. I pray for 2 weeks' time, my lord. Annexure R1 is not attested.
you are supposed to comply with the directions in order dated 10/1/20.
A lot of weeks accommodation. A week.
EVMP. EVMP is.
I'm appearing for pollution control board.
This
And
is
for
of
R3 and
14.
R4, you are.
My lord, I wasn't.
10 years.
I wasn't aware, my lord. I apologize. I'll get it done within 1 week.
Learned the government Peter 6 times. To take the final instructions and comply with the directions issued in order dated 10/1/2020. Full stop. To be listed on
My lord, the next Monday, my lord,
13th.
obliged.
I appear for the petitioner minutes.
You are for appellant,
I appear for the petitioner minutes.
petitioner.
Please minutes. There are some office objections, my lords, raised on the objections filed by respondent number 2.
Mr. Shekhar, party in person. Mother of the child. Ward.
So will be, apart from office objections.
I'm appealing for the first respondent. That
Will
the
be-
admission-
The order of the first respondent, my lords, is under challenge in the presented petition. My lords, the issue is the respondent number 2 got herself admitted under the under the government category, my lords, in the petitioner college. After 3 months after the admission was over, she got a medical seat. She withdrew her admission. She paid her first year fee, my lords. First year fee was sought to be refunded before the admission overseeing committee. My lords, the law is after the admission is complete, last day of admission is complete, that year fee cannot be refunded back to the student.
Who is for the Institute of Technology?
I appear for the institute, my lord. Institute is the petitioner.
Then why you are not refunding the fee?
My lords, the admission, my lords, was on 24 July 2015. 24/7/2015. The last date for admission, my lords, for that academic year was 15/8/2015. A request was made for withdrawal of the admission on 29/9/2015. The first year fee was only paid. And we have also filed an affidavit on 9th August 2017. It is not that we have.
The fees which are directed to be refunded is 23,850 initially paid.
Please, my lords.
And you also subsequently collected the fees.
The fee, my lords, which we have collected is the fee collected by the college, which is collected for all the students, my lords, for the course.
Maybe, but what is your right to retain the 23,850?
In fact, my lord, since the student changed over from engineering to medicine, that fee of 23,000 also did not come to us.
You have collected 68,000.
Please, my lords. That I have filed an affidavit, my lords, on 9th August 2017, that I have collected 68,850.
23,850 was a fee paid to the earlier institution.
No, through the counseling
First year's
agency.
fee. That is the first year's fee
First year.
from the counseling authority.
And you also recovered first year fee again. In
No, my
terms-
lords, we did not.
68,000 total fee you recovered.
Please, my lords, that was liable to be paid by all the students.
So you are doubly benefiting yourself by not refunding the fee. Unjust enrichment on part of the institute at the cost of the student. Isn't it?
Let's.
Sorry. Dismissed. Yes, next.
Part 27.
My lord, I am appearing for LS of score number 3, my lord. I have one submission, my lord. My lord, the at serial number 27 and 27.1 amendment has to be carried out, my lord. Amendment of the appeal memo has not been carried out by the appellant in serial number 27 and 27.1. I also comply, office objections, I will comply, my lord.
Order of objections are required to be complied with.
My lord,
Your lordship,
Please
in
take
all
down.
the appeals, my lord, conditional order may be passed.
Wait, please take. Shall be completed within 10 days.
Please.
Your lordship, the petition shall be listed thereafter. Appeal shall be listed thereafter.
Okay.
25/3.
So all up to
But-
27.7. Yes.
Number 28.
I appear for the appellants. Two office objections are raised. Office objection is respondent number, petition number, LRs of petition number 4 directly made as party. That is one office objection.
You are
It is-
found not,
Pardon me?
you are for appellant.
I am for the appellant.
146 application, you as record of files.
They have been already brought on record in the writ petition.
No, dear.
So what is the objection?
Two office objections have been raised. Number one is LRs of petitioner number 4 of writ petition directly made as party in this appeal. I have made a submission that during the pendency of the writ petition, petitioner number 4 has died and his LRs have already been brought on record. Necessary amendment has been made in the cast title of the writ petition.
The grant time, 2 weeks.
My submission is this. Office objection is required to be overruled for two reasons. Number one, they were already made as parties before the learned single judge in the writ petition. And I have made the necessary amendment of the cast title also.
So you
But in the judgment, this amendment of the cast title has not been shown in the judgment of the learned single judge.
That's
what is
the
to it?
requirement. Judgment, they are not incorporated.
That is not incorporated in the judgment. It is the mistake committed by the office in not showing the names of the LRs.
So you file some,
Get the rectification, sir.
That I can do it.
do it within 2 weeks?
Within 1 week, I shall do it.
In 1 week.
But in the meanwhile, I am seeking for an interim order for this reason.
Notice
But
of
for
the-
this reason,
This has
Notice
been
has to go.
issued. And the last this case came up, was in the year 2022, my lord. And after that, this is the first time it's coming. Notice also hasn't gone to the respondents.
steps have already been taken.
Notice has to go. Yes.
Only notice.
GA, we are direct the GA.
But first,
to take it.
I appear for.
First you
respondent one
comply with the
case.
procedural thing, then we'll see.
Please, ma'am.
14.3. Seal number 29. The Prakash image.
Please.
The last occasion, Lord, in this matter, both the Tahsildars are present before the court. Lord, the direction is to place the issue before the missing file reconstruction committee. And the file was forwarded, Lord, within a period of 6 weeks, they are going to take a decision, Lord. Regarding that undertaking, this contempt may be closed. Yeah, the missing file reconstructed.
We record your statement and dispose it of.
Please.
Lord, the same submission was placed before the lower single judge and by the order dated 21st November 2022. Lord, may kindly turn to page 18.
But we are relying on the
Now
statement
they are
of,
Having
giving
filed-
undertaking
please.
that they will going to comply, sir.
Please.
where is the order to be complied?
Next, sir.
Page 18,
Page 18. yes.
please.
The present contempt petition seeks to comply with directions contained in order 21/11/22 of law and single judge, whereby the respondent Tahsildar whereby the missing file reconstruction committee is required to take decision pursuant to the application submitted, forwarded to it by the Tahsildar. It is the order dated 25/10/19 passed by the Tahsildar was sought to be implemented. Full stop. Then a single judge directed that the decision shall be taken within 6 weeks. Paragraph. When the present proceedings come up for consideration today, learned government advocate
And
Mr.
given on
Mahendra
date to both are
makes a statement that the direction shall be complied within 6 weeks
6 weeks.
from today. Full stop. This could satisfy learned advocate, Mr.
Or else liberty could be granted to the complainant to read.
Prakash MH.
Please.
Since the statement is made by learned government figure before the court,
On
to
instruction,
the above effect, comma,
on is
On instruction, sir.
upon
and
instruction from the officer who is
present before the,
stated to be present in the court personally, give the name,
yes.
comma.
It is.
Notes, the court does not see any reason to continue with the present proceeding, the same are disposed of.
Obliged.
Observing that the statement shall be abided by. Statement made by learned government advocate shall be abided by.
Liberty
This-
could be
this
granted. May I
Disposed of accordingly. It is always the liberty. Who
to
has
renew
taken-
the,
who
because
has-
they are making the petitioner since 2019. An order was passed by the Tashildar accepting to, go for the Podi. And for implementation of their own order, I have approached in the writ petition, contempt.
Now,
Please, I can understand.
it goes without saying that the non-compliance of the order within the time stipulated as above shall expose the respondents to the contempt proceedings again.
Oh, please.
Number 30, A.D. Ramanan.
Your Lordship, I appear for the appellant. Your Lordship, there are two office objection, one office objection for non-filing of the written submission. It can be overruled because it was already, other time it was connected with other groups of writ appeal.
No, larger it was.
But Lordship, it was appeal. So that they were more interested in making submission, written submission, whereas this
Notice ಆಗಿದೆ notice.
ಅಲ್ಲ notice ಎಲ್ಲ ಹಾಗೆ it was a separate bench was constituted to hear this appeal and I got it de-linked to the regular bench because it was something different from that case. Your Lordship, only the name of the advocate B.A. Chandrasekhar should be replaced by Shauri. And of his written submission,
They shall mention the name of learned advocate Mr.
B.A. Chandrasekhar,
B. H. Chandrasekhar in place of
Shauri.
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 And your Lordship, the office objection for filing written submission is not required in this case. This is a simple issue where there is retirement age, there is a differentiation between university professors and government college professors, whereas the other group of writ petition, the age of was 65 years was there. There it was considered written submission was to be made. Whereas for this appellant, the written submission is not
necessary.
not necessary. The office objection may be ruled
Office objects regarding
written submission.
presenting of written submissions are dispensed with for the time being.
And the appellant, the other office objection should be very minor. I can do it in the course of the day. Appellant number 3 has to be written instead of appellant number 2.
You do that, rectify the mistake.
Your Lordship, there is urgency here in this case.
For compliance of the rest.
Urgency, sir.
The first time this objection was raised, first time,
Compliance of the rest of the office objections, 3 weeks time is granted.
1 week is enough.
You do it within 1 week.
3 weeks. 25-3. Number 31.
May I please, Your Lordship,
Dilpito Kumar.
appear for the appellant.
My lord, this is a landlord tenant dispute. I appear for the appellant who is the tenant. My lord, I have been a tenant of the respondent landlord for nearly 60 years. There were no disputes. The final, the lease agreement was renewed in the year 2015 for a period of 10 years. My lord, because of during the COVID period, the rents could not be paid. So for almost 14 to 15 months, rents were not paid, during which time the respondent landlord terminated the lease. And the matter went before the arbitrator. Arbitrator passed.
Amount due is 23 lakhs.
No, my lord. Now, all the rentals have been paid. Now, in the award, the arbitrator passes 3 main orders. My lord. The first claim is to vacate and hand over the possession. Second is to pay all the rental arrears. Third is to pay the mean profits, which was calculated as per the contract terms at 10,000 rupees per day. Now, in fact, during the arbitration proceedings itself, amounts were being paid towards rentals, and as on today, the rentals are being paid on a monthly basis without any default.
So what is the amount?
My lord, the rentals have been paid about 1.62 lakhs.
The amount paid.
Now the mean profits, yes, ma'am, the mean profits were not paid. Now the mean profits comes to 10,000 rupees per day as on today, roughly about 1.3 crores. my lord.
All rentals are paid.
All rentals are paid and we are paying monthly rentals. We are without any object.
Your lords,
There is one dispute that he is claiming that he has paid 50. They are claiming not paid. Let them work it out.
mean profits continue to accrue because they have failed to vacate the property. And as of today, there is about 1.5 crore that is pending.
Any matter is pending, execution pending.
Execution is pending.
is
It is
pending.
coming on 7th. And the court has given me an ultimatum that unless you get an interim order, I'm going to issue delivery warrant. So this honorable court on the last occasion was pleased to pass an order, but subject to deposit of 50%. My lord, that's a huge amount. My only prayer was that my rentals which are being paid can be considered as the deposit for the reason that, my lord, now each party in that case will not suffer because having to pay again a substantial amount. It's a textile shop. Having to pay a substantial amount, and my lord, it's a 60 years relationship. Never was there a default in rentals, only because of that extraordinary circumstance.
Want to go for mediation?
My lord, I
Your
am
lords,
always open.
several
In fact,
rounds have
multiple
already
attempts
happened.
were done.
Several rounds have already happened. In fact, we even offered that if 50% what is being ordered by the court to be deposited, if that is paid to us, we will close the matter, we'll settle it.
No, but vacate, they say
But
have to
there
vacate the shop.
they seem to, first of all, be in financial doldrums. Now, what happens is, my only concern is that the respondents are senior citizens and they have fought this case for quite a long time now. It is not my intention to cause them some undue hardship, but it is only to secure their financial interest. As of today, there's 1.5 crore.
Your tenants in 60 years?
60 years.
60 years. Why don't you work out something?
Your lords, for around 2
And the
years. they
respondents are
played
well
the-
placed in US. They are all returned CFOs from big companies settled in USA.
Your lords, these, they rely on these incomes, your lords. Equally, I'm not saying that they are not financially well-to-do, but they have equal financial obligations.
But that income is being paid. Had there not been a breach, they would have been entitled to the rentals only. Those rentals are already being paid.
Whatever the 50% to be paid, you work it out in the execution. We'll direct accordingly.
My lord, 50% would come,
Calculation.
50% would come anywhere in the range of 65 to 75 lakhs.
You have to pay. You
Uh,
are a tenant, sir. You want to
I
start
agree.
on the-
No, that's why I've only filed an application to say that had I been a tenant who had not paid the rentals or the mean profits, the order would have benefited such a deviant tenant by paying the rentals. But I've already paid all the rentals
You
up
want
to
an
date.
interim order and you want to make a default. Now your appeal will go for default.
No, my only submission is this. Now, both the party, I do not want them to suffer a loss. Hence, rentals are being paid regularly. 3.5 to 3.9 lakhs are being paid every month.
Years, you 50% you paid before the commercial court, sir.
But my lord,
Correct, then,
the
you can
difficulty
use
is,
protection provided if you are.
my lord, this is the only business they have. This is the only business they have.
But yeah.
And to pay that kind of a substantial amount at this stage.
They may be well off, that is different. They may
No,
be-
I'm not on that. I'm not on that. No, because he,
That mean that they don't need a justice. Sir. No, but let him deposit. It will be deposited in the court.
That's right.
It's the deposit to the court.
I just deposit to the court.
my lord,
Deposit in the court.
my lord,
Executing
in
it.
fact, during the talks, in fact, now this lease itself would have now terminated in another 1 year, March 2025. My lord, in fact, I told them that I will increase the rentals by another 50,000 rupees for the period. And I will, in fact, give an undertaking that I will not continue after March 2025. Even the deposit of 15 lakhs, I do not seek for a refund. They have a deposit of 15 lakhs also
You want to continue with the premises?
after March 2025.
25.
Because the term itself would have ended in March 2025, the lease period. So I will not continue and I will not hold over the property. The 15 lakhs that is there in deposit, they can adjust it.
Go for mediation. Go
They
for
have a
mediation.
Your lords, in fact, when the
I'm
matter
open to
was
that.
first
I'm
filed,
open to mediation.
Go for
when the matter was first filed, the court directed both parties to actually go into mediation. Several rounds of mediation has gone on.
Not only problem, if there is mediation also, some time, breathing time may be needed in the execution case because 7th the matter is coming, they'll issue delivery warrant. The entire family will come on the streets. That's only problem.
50% there is a direction of-
50% no concession.
My lord?
About 50% is the direction of this court.
Yes.
Yes, ma'am. Yes, ma'am.
Interim order.
Yes, ma'am. While passing the interim order on the,
13, 12, 20, then you comply, we can't help.
Lordship, my lord, can it be, this is my submission because I also know how much my client would be in a position to pay. If there is some concession on that, both in terms of the,
Reviewing the order.
no, I'm definitely, in the light of the fact that all the rentals are paid up to date, only not on the concession of.
It is an order of the coordinate bench, 13, 12, 23. We can't review, modify so lightly.
No, only while considering the fact that the rentals are already paid, about 1.62 crore rentals have been paid. Up to date, you're paying every month without any delay.
Typical order is that
So
you have
4
to
weeks.
pay award amount, not the rental amount.
A balance amount, balance award amount. The word used is balance award amount. Yes, ma'am. Then may I stretch my submission to one last thing, my lord. Can some time be given? 6 weeks, 6 week time can be
My
given.
only respectful submission in this record.
Mr. Jul. Yes.
Your lords, 4 weeks time was initially given to them,
We are-
during which they didn't even ask for any relaxation.
We'll give further forward from today. Learned Julfikar, Julfikir, Kumar Shafi.
Yes, ma'am.
For the appellant. Request the court that the time may be extended to deposit 50% of the pending award amount, which was directed to be deposited as per order dated 13/12/23. He submits that for unavoidable reasons, the amount could not be deposited within the time stipulated in the said order. Full stop. He also submitted about the discrepancy in the calculation. Full stop. Request of the council for the appellant to extend the time is exceeded to. Full stop. The amount as directed in the order dated 13/12/23 shall be deposited within 4 weeks from today. Full stop. Any calculation dispute shall be sorted out before the commercial executing court by the parties. Full stop. It is also open for the parties to engage into the mediation process to solve the main dispute. Full stop.
But as far as the amount for deposit is concerned, just to make things clear so that it doesn't lead to a dispute tomorrow, of the principal amount,
Whatever.
of the principal amount, the principal amount.
Award.
Because otherwise, again, the interest also.
Interest,
adds-
everything, award. Don't be clever.
No, my lord. I'm only trying to reduce the burden of the client. I'm not.
No, you make.
Because I do not want to make a calculation and
your
then
submission,
come before this
that's
court.
all.
That's why I'm beforehand itself, I'm just making a submission to this court.
Not a single change in the word of the earlier order except extension of time for.
Yes.
Obliged.
Grateful.
So to be listed after
4 weeks.
6 weeks.
4 weeks, obliged.
Grateful.
Obliged.
19/4. Number 32, the Sampak here.
For complaints, my lord, this matter, my lord, there is 2 complaints, my lord. The annexure is page number 7 is the
I
order.
appear for the respondent, Lord. The direction is to consider the representations, 2 representations of the complainant, Lord. In pursuance of the same, Lord, we have conducted survey to identify the encroachment on the major district road. And a sketch was prepared, Lord. An endorsement also issued. We have filed an affidavit to that effect. Lord, the directions of the Honorable Single Judge has been complied with. Lord. We have initiated action. And in presence of the encroacher as well as the complainant, a survey was conducted, sketch was prepared, and an endorsement was issued to the accused also, complainant also, Lord. And we have issued a notice to the encroacher to remove the encroachment to the extent of 3/4 of Gunta.
It just has been handed out to me. Like just verify, my lord, this complaints. I just need a time to on this, my lord.
Removal of encroachment, any action is taken, sir?
We are initiating action, Lord. We have issued a notice.
Records is not disclosing anything. Only your making a report that 816 square feet is.
That the endorsement is not reduced, my lord, by mistake. It's with me.
They have made a survey. 800 square feet of public road is enclosed and put up the construction.
Around 816 square feet has been encroached on the major district road. We shall initiate, my lord, action in accordance with law within a period of, my lord, 12 weeks. The assistant engineer is present before the court.
Please, my
Are
lord,
you
there's
satisfied?
two, my lord, they just.
Are you
hand-
satisfied?
My lord, I just, my lord, just verify because they just gave it me now. I just have clarification on my client, my lord. So I'll just have it on next week, my lord, just come up with
They are
the.
going to take action for removal of 816 square feet of encroachment.
Please, my
What
lord.
else you required?
My lord,
That's
please.
what you required in this context.
Please, my lord, I'm satisfied, my lord, but I just,
They are giving undertaking.
please, my lord, I just have some
Yes,
instruction on my client.
request
my lord.
is, in one of the representation is that without license, you should not allow. And another representation is to clear the encroachment. There are two representations. In fact, we have considered the representation, initiated action against the encroachment.
Just a week's time, my lord, I just not to verify, my lord, just I just seek instruction on this, my lord, that is just a week's. And regarding the other representation that, my lord, to not issue a license, my lord, considering this, my lord, on 18/8/2023, this honorable court issued further direction to the panchayat officer, my lord. My lord, that has to be complied, my lord, but they again come up with the same plea.
That's my, next meeting you'll take action to initiate criminal proceeding. Second.
Panchayat.
The two,
Panchayat.
there are two representations, my lord, and two officers.
Jilla Panch.
My lord, the
Gram Panchayat. Gram Panchayat, in next meeting, you take a decision to initiate the criminal proceeding against the complaint as well as the other two.
my lord,
All of them have constructed without license to the Gram Panchayat.
my lord, may just make one submission. My lord, they say the issue a criminal case, my lord, this panchayat office says that, my lord, if there any encroachment or without person construction building without license, they say, my lord, they don't have any power for demolishing that property because they only say the act doesn't provide them. My lord, they only say the only remedy if illegal construction has been done to initiate a criminal case.
Yeah, we have heard what is undertaken.
Please, my lord, my lord, please, my lord, that submission was.
Action now.
Please, my lord, that submission, my lord, was not been accepted by this honorable court, my lord, and said 18/8/2023, detailed order was passed, my lord.
They are now saying that they'll take action. Learn a single judge. Not learn a single judge. This court passed order dated 6th September 2022 in the writ petition number 52716 of 19. Whereby the petition was disposed of, directing the fifth respondent as the Gram Panchayat, Devaram Block, so Halli Panchayat, and the ninth respondent, this assistant executive engineer, to pass appropriate orders in light of the representation stated 22/2/19 and 18/3/19 submitted by the petitioners. The representation were with regard to removal of illegal construction, encroachment, in contravention of the Panchayat
May submit.
Act and the notification dated 18/10/2004 issued by state of Karnataka. The encroachment cum illegal construction was put up by 10th and 11th respondent, who were the adjoining owners. Paragraph, the proceedings, these proceedings witnessed order dated 18/8/23 passed by the coordinated bench, in which it was internally observed that the local bodies are duty bound to take appropriate actions against the illegal obstructions, encroachments. And when the local bodies are armed with necessary powers to effectively implement the provisions, they cannot remain silent spectators. Post of paragraph, the court observed that the Gram Panchayat was expected to go beyond to the Gram Panchayat was expected to discharge its statutory duty and take appropriate action for effective implementation of the provisions of law. Full stop. Accordingly, in that order, the court directed the Gram Panchayat to take necessary steps in accordance with provisions of law. Paragraph, when the present proceedings come up for consideration today, learned government pleader.
May I submit? On the last
Mahendra as well
occasion,
as learned
5/2/2024.
Advocate Mr. Somesh for the.
No, what I submit was, so far as Gram Panchayat is concerned, we have to initiate for building construction without the license, you have to take action 298. So far as construction road is concerned, there is for third respondent to take action, not for second respondent. Second respondent will not taking action for construction of building without the license.
This is a case.
Wait, Mahendra stated that the directions will be complied with in
12 weeks.
12 weeks.
We have issued notice, notice to the encroachers.
12 weeks, stating that the notice is already issued to the alleged contemptor.
With the cooperation of the local.
Full stop. Learned advocate Mr. So-and-so, so-and-so appearing with Panchayat also stated that they already
We will
taken
take
this-
a decision in the next meeting to initiate criminal proceedings.
taken the steps and they shall be further carried forward and the steps shall be further taken in the
For constructing the building without the license.
by considering the issue in the next meeting.
Yes.
Next general body meeting
Yes.
of the Panchayat. By,
Huh?
and the license will be cancelled.
No.
There is no license.
No license.
There is no
For-
license.
For constructing
Since the-
building.
since the
for
construction is
constructing
without
license, we will initiate a criminal proceeding.
Since the construction put up is without license. Full stop. Since the respondents are taking effective steps in the direction of compliance of the order of this court, comma.
My submission is upon the instruction of Assistant Commissioner who is present.
He is representing A3.
So government upon the instructions of so and so. He stated to be present in the court with designation. Since the respondents are taking effective steps to comply with the directions of this court, comma. The contempt proceedings are closed.
Please, my lord, the liberty, my lord, if they don't, if they doesn't comply to revive this petition.
Respondents shall act in accordance with statements made before this court. At this stage, learned advocate Mr.
Mallikarjun NK, my lord. I'm representing Mr. A. Sampath, my senior.
Mohammed Tahir, no.
No, my lord, 32 serial number.
Sampath.
So I'm representing Mallikarjun NK, my lord.
So for learner Mr. Sampath hai, stated that the liberty reserved, may be reserved for.
Please, my lord, if the-
applicant to approach again, full stop. It is to be observed that non-compliance of the statement shall give fresh cause of action.
Yes, public.
To approach the appropriate. Fresh
Magistrate,
cause of action to the.
please.
Proceeding that is.
Time limit for them to comply, my lord.
12 weeks ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
My lord, the Panchayat did not say, they only said the next meeting they're going to take.
Yes.
Next meeting is going to be held when?
Within a week or so, that is what I have been told.
Next meeting, which shall be held within 2 weeks from today.
Yes, I'm obliged.
See number
In
33.
the name of which next meeting shall be.
Number 33, BK Manjunath.
My lord, pray for a week's time to comply with office objections.
Nine
Pray for a week's
objections
time
are
to comply with office objections.
Like court fee, condemnation of delay.
2 weeks.
1 week is fine.
1 week.
Much obliged.
Number 34.
My lord,
Mohammed Tahir.
my lord, the dispute arose because we had, railways had demanded a fee, additional fee at the time of after renewal, my lord.
1,43,000 was paid, your lordship.
We had asked.
Pendency of the appeal.
There was a demand for, demand notice was issued to them, annex, page number 123, my lord. This was challenged before the learned single judge, my lord. Thereafter, my lord, while this matter was pending, though the case was dismissed, this honorable court had passed an order, my lord, on 26/7/2023 to conduct survey, my lord, during the peak season. Lean season, my lord. So as per the order, my lord, we have also conducted the survey and there is a difference amount of on
91,000.
91,000. This amount they have to deposit, my lord.
This
And
amount also
we'll
within-
consider their representation and this matter can be disposed of, my lord.
That's just my instructions are this amount also they're willing to deposit before the authorities within 2 weeks, your lordships. The difference amount of 91,702.
We'll consider the representation annexure G and
So it is reduced already now.
This 91,702 also I'm willing to deposit within 2 weeks, your lordships. The difference amount during the pendency of the appeal, 1,43,000 I deposited as per the demand notice. Subsequent difference amount of 91,702 within 2 weeks, I'm ready to deposit, your lordships.
So you're agree for 2,41,000.
2,41,000.
my lord. And we'll consider the representation annexure G, my lord, and it can be disposed of. That was their representation, my lord, which they claimed to consider before the learned single judge, my lord. We'll consider that representation and it can be disposed of.
We will give now this railways document. Dispose of.
Obliged. Obliged.
They appear for the appellant, my lord. My lord, I pray for 2 weeks' time to comply with the office objections, my lord.
Learned Gaur G, it's 2 weeks to comply the officer.
Number 36.
Please.
Mr. Bal Gangadhar, yes.
For the complainant, my lord. My lord, the compliance undertaking is not complied with them.
Your lordship appearing for the accused number 3 and 4. Accused number 4 is in maternity leave, so seeking 3 weeks' time for compliance affidavit and to file wakalatnama.
My lord, several
Sir.
So how many days you will going to comply the order?
3 weeks, your lordship.
Within 3 weeks will be complete.
Please, my lord, I have also, my lord, direction is by the honorable division bench to pay all the benefits, salary, promotion, everything, my lord. That they challenged unsuccessfully before the honorable Supreme Court filed another review, everything went against them. My lord, I have also furnished, my lord, the calculations also, my lord, how much I am entitled. My lord, if they undertake to make all these complaints, my lord, I will be very happy.
That is what they are doing.
Please.
Submission work, madam. council for so and so for R3, A3 and A4 in 36. Where you can pass on a memo, madam.
Pass in a memo,
Memo
specific.
of undertaking,
Yes, your lordship.
that you will do it in 3 weeks.
Yes, your lordship.
Please.
Yes, your lordship.
Today we'll pass the memo or tomorrow.
Now she will
Your
give
lordships.
it to sheet of paper. She will write it and,
In both the matters, my lord. Please.
okay, now. Senate council so and so for the A3 and A4.
Tomorrow, your lordship.
by the
Tomorrow.
memo.
Tomorrow.
Okay.
Tomorrow.
Please, please.
Tomorrow we'll be taking up first,
Yes, ma'am.
disposito,
Please. Much,
at 10:30 it's.
much obliged.
37 and 36.
Both matters.
Posted on the top of the list.
Much obliged.
Number 38, Naveed Ahmad.
The complaint lords. Lords, with the liberty, lords, to appear before the Leonard Single Judge. Lords, the Leonard Single Judge, lords, has granted interim order of stay. Lords, to the lords, to the respondents. With the liberty to implead before the Leonard Single Judge, lord, the contempt petition can be dropped, lords.
Liberty to implead.
Implead before the Leonard Single Judge. In WP number, lords, 26864 of 23.
We'll permit him to implead in
With liberty, lords, it can be disposed. With liberty, the contempt can be dropped, lords.
Shri Naveed Ahmad, Leonard Council for the complainant submit that he may be permitted to implead in WP 6864/23 for the honorable single judge. And this contempt may be closed. Good stuff. Mission accorded. Contempt stands closed.
Going to implead in this.
No, not here, in this. This order cannot be given in effect as there is a change. We'll permit him to implead.
Dispose.
Blade, lords. With liberty, lords.
You are permitted.
Blade, lords.
Number 39. T. Sheshagiri Rao.
Third respondent.
Hearing for the.
Iris.
Matter has to be heard.
This will take.
You please comply, any office objections are there? In 39.1, there is one non-compliance of one office objection. Sampath.
39.2, my lords, my instructions are in 39.2, it's been complied of. Copy to be served on the government. Instructions are, it's been served.
There is one Krabali, there is a fifth time, it is non-compliance fifth time.
Allah, Madiyare anತಾರೆ. It's only service of copy on the government advocate. My instructions are, it's been done.
No, it will be done.
It is done. Okay.
I shall send on to payroll.
Then we'll make note 39.2, Leonard Council for the petitioner. Appellant, cross objector and cross appellant.
That we'll serve it today
Submit that
itself.
the office objection has been completed. Office to verify and note. One further, this one 39.1, non-filing of memo acknowledging having served the copies to the advocate for respondents. Copies received already. Shri Panindra Leonard Senior Counsel submit that the copies have been received. Hence office note shall be deleted. 39.1. So 39.39 was same. Office note be deleted. So we have to
Here,
hearing B group.
let's writ appeal, B group, it's not B group. In writ appeals,
Still go hearing on main.
main only it has to be.
Because
Yes, post the matter for hearing. No, formal admission, we have to make this one.
yes,
No, this Leonard Single Judge has only followed the division bench.
39.1, 39.2, all in all the common, admit, post for hearing.
could there be a date, minutes, because
Yeah, we'll certainly give it. 4 weeks.
only one request.
Term order extended.
Only one request, minutes, what we had. Here, some senior citizens are there. There is some procedural, I would not say defect by itself.
Status
Non-compliance by the original inquiring authority.
But my only request is, status quo is, now the tenants are not even paying me rents. Nothing is happening. That's my
And
problem.
that is exactly my problem also. Tenants
Sir,
have
on the
started.
last hearing, mother told that she will collect the rent and pay 1 lakh to the.
Yeah.
You collect the rent 1 lakh. You collect the rent and pay 1 lakh per month.
There are two tenants who are vacated because of this. I appear for the senior citizens, father and mother.
Otherwise, can I request an early date, my lord, so that
For your statement,
my lords,
we'll collect the rent and pay to the son.
my lords, we will collect the rent, my lords. We had offered 1 lakh to be paid. My lords, I am the son.
you
My lords, let him, my lords, I think, let him start collecting the rents. Keep 1 lakh, deposit the remaining back to us.
I said I will pay 1 lakh. Now he said, because I have, my lords, other things also to maintain. Even I have children and, my lords, property tax.
Mother was very generous. Last time he offered, son offered.
Lords, I understand.
Mother offered him 1 lakh.
Property tax has
They are
to be,
the two.
my lords, otherwise some expedited date, my lords. This issue once for all, my lords, is decided. Otherwise, we'll only be.
But you collect the rent from the tenant, sir. You retain 1 lakh, pay the balance to the mother.
It should be fetching around 5 lakhs. my lords. Let
Lordship,
him,
that's the lordship saying that we'll mention it in the order.
In the order itself.
My lords, we'll retain about 1.5 my lord, because I have to pay property tax, my lords. Property tax itself will run into several.
Lords, instead
All
of
right,
all that,
I'll leave it to my lords.
You are
As-
for whom, mother?
The son.
Son, learned senior Mr. Phanindra. Fairly stated that while they would go on collecting rent on behalf of the son,
Tenants, my lord.
tenant, comma, out of the amount collected, total amount of 1 lakh will be paid to the son.
No, I am the son, my lords. They want me to retain.
So you will retain the 1 lakh and the rest will go to mother. The rest of the amounts will go to the mother.
may only,
My lords, a little more than 1 lakh, my lord,
Lords,
because
only
he's got
request
two
is this,
kids.
lord.
For the time being, you make it, then you make a further submission.
Only one request, my lords, I have. Instead of saying it is
Instead of
1,
they collecting.
1
rent,
lakh,
now
2
you
lakhs,
are
my lords.
They themselves. are
Let it
giving
be
after-
quantified in terms of a percentage, because what has been agreed, my lords, is.
Now it is
They are given-
interim arrangement.
Please,
Please, my lords. Now, because, my lords, tomorrow they must not say, there's only one tenant, he's only paying 1 lakh, I'll keep that 1 lakh. That should not be a issue, my lord, because tenants will be coming and going.
but we'll have
It
to.
should not be a situation where the tenant says,
The
there's only
reason
one
why
tenant, he's paying
we
1
are
lakh, I'll
asking
keep
you
it.
collect the rent and pay 1 lakh to him.
My lords, all I am saying, my lords, is let him take 20%, the 80%, let it go to the parents. They will not live for too long. It's just a matter of another, possibly max, my lords, a couple of years.
That's not possible.
Lords,
That is why, my lords, that quantification of that figure, my lords, is a bit dangerous at this
yeah,
point of
before my
time.
lords, if something like that I do,
You
they
make
can
a
always
further
move the court. I can't-
Quantification of such a figure is dangerous at this point of time.
The present is an interim arrangement, which may be subject to further modification, depending upon the developments which may take in future.
Lord's only point is he has to pay us at least 3.5 lakhs of whatever he collects, minimum, my lords. That is, he can keep 1 lakh. That, my lords, that has to be fixed. Tomorrow he must not say, I will index someone else, because the tenants are indicted by me as on date. Please, my lords, the tenants have been indicted by me as on date. There are lease deeds executed by me. I owe them advances at this point of time. So as long as he is a rent collector, it's all right. But if he says, I will induct fresh
If any
tenants, that will
tenant
be a
is
problem.
vacated and if new tenant has to be, you make a mention before the court.
So, my lords, I will have to induct a new tenant. Ultimately, my lords, I will have to induct a new tenant because of the order. So, my lords, the tenancies can be inducted by me, my lords, I will take care.
Want to collect the rent.
My lords, I can collect rent and, my lords, possibly whatever he wants, a percentage.
That's why.
My lords,
my
all
lords,
I'm saying, my lords, is.
My learned friend
Don't
is going.
complicate the things, sir.
I have
Let it-
succeeded before the single judge. My learned friend, my lords.
On what ground, my lords, I'll just point out. On what ground, I'll just point out.
We will hear on those things on merit.
Yes, that is why, my lords, I said, this matter, my lords, there is a bit of a procedural non-compliance before the inquiring authority.
Minus 1 lakh, you'll be getting the amount of rent regularly.
Whatever, if there is a fixed sum, my lords, if your lordship say 4 lakhs, parents is entitled, 1 lakh, he is entitled. I'm all right with it for the moment.
I will retain 1 lakh and as of now, that's.
Let him say, my lords, what is it he will pay me? 4 lakhs, all right.
My lords, then I'll have to come back on that.
You are complicating it, Mr. Sunil. No,
My
no.
lords, this is
I
getting.
understand.
I'll have,
You have collected the rent.
not yet, my lords,
But
that's the, we have to still collect because of this dispute, nobody is paying me.
Time limit. Time limit.
No, every month recurring rent. So
Some ex-
arrears you collect it, you retain for all those respective months, 1 lakh, pay the balance to the mothers.
Parties shall maintain the account of the
Please.
Status quo, my lord.
That,
There will be a proper accounting of. collection.
Status quo, my lords, because possession was rendered by me.
I don't know. Please.
No, no, my lords, I can point it out from records if needed.
Whoever who rendered the possession to the tenant is nothing to do with the interior order.
Exactly, my lords, exactly. All,
He
if
will
there's a
collect
new
at the-
tenant which has to be inducted, I'll have to induct him again.
No, my lords, he is going
Because,
into
my
other
lords,
issues which is not.
No, my lords,
So
the
far as
first
amounts I
single
understand.
judge, my lords, has protected the position of the parents. Because
We think that for the time being, this arrangement will work. Then we'll see what to do,
Let's say, sir.
future date.
it may not, it might lead to a complication because what is not quantified to me, my lords, that is becoming a problem. That is all. If your lordship says even let the parents get only 3 lakhs, he can keep 1 lakh, I'm okay with it.
May I just
Cannot
request
put
this?
that thing to see small.
Whatever it is
3
fixed,
lakhs,
my lords, I am only saying,
So the council is saying that what amount you are going to pay.
My lords, I will have to check, my lords.
let him
My
check and
lords,
come back.
this was going on.
I have no issues, my lords, let him check it.
This is
Take
the
back
issue.
instructions
My
and-
learned friend is only complicating the issue. Your lordship may expedite the hearing and consider that.
You get prepared, sir. You submit your synopsis and.
Yes,
notes
my
and
lords,
everything.
we'll do
If
that.
your lordship fix a date, I'm ready.
So if some complication rise, the court is there.
Yeah, exactly. That,
Undoubted.
lords, we are before my lords, we know.
Undoubted.
We
Undoubted.
know where we stand also. Lords, if something like that I do, we can always move the
First,
court.
let them collect the rent and let the money come to you, sir. Whatever 10,000, let it be.
Please, my
Then we will take a call.
Yes.
Huh?
for that,
Let
for
them,
that,
let them, let
only
him
for
collect the
that
rent
reason,
from the
only for that
tenants and,
purpose, I would request
retain 1 lakh
a
and pay
date be
whatever
fixed
the
in the
debt.
next week to understand how much he can collect
No,
and how
no,
much he
no,
can.
next week. You get prepared yourself for.
I am ready, my lords, I am ready. A date of your lordship's availability, that is.
Keep after 6 weeks.
It's-
6 weeks. After 6 weeks.
No, no, my lords, I think by then, too much of damage will be there. That is my only request, too much of damage.
4 weeks ಅಂತ ಹೇಳಿದಿರಿ. Then we'll going to 8 weeks. ನೀವು ಹಿಂಗೆ ಹೇಳಿದ್ರೆ.
ಬೇಡಿ ಸ್ವಾಮಿ.
ಆಗದೆ ಇರೋ ಕೆಲಸ ಮಾಡಬೇಡಿ, please.
If you, if your
Very
lordship
next
can
match,
fix a date, that
what
is all
is-
what I want.
4 weeks, madam, give the date after 4.
Come after 4.
18th
In the
April.
meanwhile, my lords, we may be able to move the court if there is any problem.
Always.
100%.
Please.
Always welcome.
It is always.
Number 40, Stage K Acharya.
Not the office objections regarding the production of the color photograph, page number 267 to 20. That has been produced by the other side. Seeking exemption of that. That is the only
Regarding
objection.
production of color.
Color
photo-
photo.
Photocopy of the document is concerned. Council submission is accepted.
This is a matter, my lord, with regard to the construction of the electric towers in the scheduled land belong to the petitions which are agricultural lands, my lord. The learned single judge, while passing the order, my lord, consider the prayer. Consider the prayer for compensation only, my lord. There is an order passed for passing an inquiry, my lord, as per the
Alignment
requirement.
is concerned, electricity line cannot be drawn as per your alignment.
No, it's not as per Mela, they are not driving as per their survey alignment
No,
itself.
they are single
That,
judge
that
order.
objection I have raised before the,
Today is available to you under the
Mela,
Telecast.
that may be kept open, Mela, because before
It
the,
is kept open.
it's not kept, Mela. It's only with regard to the representation regarding compensation only. Let us
Under section 16(3) of the telegram.
Mela, kindly look at the order, Mela.
It is kept open. See page 49.
Mela, you may kindly see, Mela.
It is kept open.
Mela, paragraph number 5 only, Mela.
5.
This court must also observe page number 47. Page number 47. Well, it has to be determined only with regard to the compensation factor. So, Mela, our grievances has to be placed before the Mela authority, Mela, that may be kept open, Mela. I will be satisfied, Mela. It's not according to my subject and whims and fancies.
Presentation, you can make submission about the.
Mela, this also I will make, Mela, that may liberty may be granted, Mela. So that, Mela, I will make a representation to the.
We'll say that the direction number 1 requiring you to make representation will also include the represent about alignment.
Yes, Mela, my writ petition prayer may be kindly seen, Mela. 64, Mela, page 64. The prayer column number C, Mela. So that, Mela, least damage could be done to the property. Mela, it's not so difficult for them. It is only for the purpose of protecting the agricultural field, Mela. It is source of our livelihood.
Prayer C.
Please, Mela. That may be kept on. If it is feasible for them, Mela, let them do it, Mela. If it is practically impossible, Mela, let them go on with the matter.
Minimizing the damage.
Yes, Mela.
So that is alignment.
Prayer C, prayer C. So that, Mela, some, there are some temple structures, my lord, the all other are there. They have to see the practical difficult. They cannot, my lord, go on with the construction, my lord.
by causing damages to the property. So that is my,
We'll observe that the authorities will see that the minimum damage is caused.
please, my lord, that may be observed.
We'll see.
Please, my lord.
Subject to that limited observation dismissed.
Please, madam, that may be kept open, madam, before the DC, madam, because DC did not conduct the inquiry at all. That is why this honorable court, madam, directed the district magistrate to conduct the inquiry afresh. Now, madam, they are proceeding with the work, madam, before determination of the compensation payable to the petitioners, madam.
You are Sudesh Kumar Acharya.
Please, madam.
You are senior.
No, madam, I am advocate.
Designated, but he is senior.
I did not say designated.
Please. Madam. That may be protected, madam.
Thank you.
Observations, madam.
Yes.
Given the recess one.
We'll do that.
Grateful.
Yes.
For 41,
Case, my lord, notice has been issued.
My lords, appearing for the accused, my lords, have been instructed to file wakalat in the above matter, my lords. Within a day or two, I will file the wakalat.
Since, my lord, order came to be passed on 31st July 2023. And, my lord,
You are for number 2.
Please, my lords, 1 and 2, my lords.
Drawings are submitted to them.
please, my lord.
Drawings and might be drawings are.
No, not it. Therefore, my lord, I am before you, lords.
No, you have submitted your drawings.
We have submitted this representation and, my
My
lord,
lords, we
copy
have
of the
filed
order.
a writ appeal. It was listed today, my lords. We have filed a writ appeal against the impugned order, my lords.
And, my lord, insofar as writ appeal serial number 6, my lord, that they have not for complied with office objections. Now, after lapse of 4 months, my lord, after giving representation.
Serial number 6.
Serial number 6, my lord.
So after 3 weeks, you comply with both will be respected.
No, yes, insofar as contempt is concerned, my lord, that from 2 years, my lord, that they are dragging.
Learned, so and so undertakes to file wakalat to the accused.
Short date may be given.
And further submitted that writ appeal 211/2024 is already filed and posted for today.
Compliance of office objection.
This contempt along with writ appeal 211/2024.
Short date may be. Any date, my lord, short.
Yet ಕೊಡ್ತಾರೆ 4 weeks ಅದಕ್ಕೆ.
ಅಲ್ಲ, 4 weeks ತುಂಬಾ.
Serial number 6, which date you please post this case on that day.
Which obligation?
10.
For the appellant, you know, the Sound Court has issued the emergent notice as well as the permitted to take hand summons, my lord. The hand summons has been served to the respondent 2 to 4, my lord. The respondent 1 and respondent 5 and 6 refused, my lord. For that effect, I refuse to take no hand summons, my lord. And this is a service matter, my lord. And the transitions.
R156 करेंगे. R156. Now there is a mistake in your cast title, sir. Valalkere, they have mentioned Deputy. Where is the
No,
deputy?
my lord. In the writ petition, my lord,
In the Valalkere, which is a.
no, kindly see, my lord. In the writ petition filed by the respondent 1 and as well as the impugned order, my lord, they have mentioned the oral care only. Yes, my lord. Yes, the selection committee, my lord, is head of the selection committee is in the oral care only. That's why, my lord, the writ petition filed by the respondent 1, it's himself.
Sir, one thing, you please correct the cast title and take a fresh.
No, my lord, the writ petition filed by the respondent 1.
Sir, you are the appellant, you correct.
Now, appellant, my lord, in the office, my lord, if now corrected, my lord, they will refuse to list the matter, my lord. Because, my lord, in the writ petition as well as in the impugned order, my lord.
You correct the address first.
No, I will correct, madam. In the meantime, in the seeking the interim stay of the order passed by the this is matter, my lord.
It is a 84 delay is there, no interim order.
No, kindly see, my lord, notice is already served, my lord, hand summons already served. And now, my lord, they are all taking all the steps. In this matter, my lord, the respondent 1 year, he has not challenged the appointment order of the appellant. Only selection list has challenged, my lord.
Error, 115 and 15 and 6 refused. Rest of them, 2 and 4.
All the respondent 2 to 5, my lord, is appeared by, represented by the government advocate before the learned single judge, my lord.
Copy of the.
No, I was served, madam, served.
Direct the GA to take notes.
And so far as the interim order, my lord.
One nimshari, sir.
Yes,
Don't go fast.
So number 6 is already appointed.
yes, my lord.
But I have no copy.
No, after serving only copy, my lord, their petition will be registered.
Let the DGP take notice for the 1, 2, 3, 4, 5, 1, 6.
2 to 6, my lord.
Deputy Commissioner. And they are given. Okay, is it allotted? They refuse to accept. Commissioner, ticket for permit. They have to correct this.
Correct it.
Address of the 5, 4, 5, 6, please correct it, sir. Learned counsel for the appellant seek time to correct the address mentioned in respect of R 4, 5, and 6 permitted. Full stop. Learned GI is directed to take notice to the R 2 to 6. Full stop. Notice to R1.
No, already he refused, my lord. He is refused.
Notice to R1 dispatch on 29/2. We await notice of R1.
That is the emergent notice, madam. In respect of the hand summons, my lord, she is refused. For that effect, I have filed the affidavit.
Okay. R1, since DG, R1 has refused the notice, service is self-sufficient. What about delay, madam? Copy, now you serve the one set of
Yes,
copy to.
yes, I will serve, my lord. In the meantime, my lord, they are
Counsel
taking
for
steps to
the-
relieve me, my lord. Relieve me. Kindly hear, my lord. The appellant as well as the respondent filed the applications for
When
post
the
of.
court is dictating, please have some patience.
Please.
Learned counsel for the appellant is requested to serve the one set of copy to the learned government advocate. Full stop. So delay or what is the interim order you are asking?
Interim stay of the impugned order, my lord. Stay of the interim order.
With that order, sir.
Yes, my lord. The appellant, my lord, appellant as well as the first respondent filed the application, online application for the post of Anganwadi helper. She has not submitted all the required document.
And on modern delay. Okay. Learned GA has no objection to IA 2/24. Full stop. IA 2/24 is allowed, delay of 84 days is condoned. Full stop. Ad interim order, IA 3/24. Subject to modification.
Please.
Oh, please serve the copy.
Yes, sir. Now it's I will serve the copy.
Waiting for appellant.
I prefer the appellant in this case, please. Except for production of the colored photographs, the rest of the office objections have been complied with. Please. Plus, the appeal please winners arises out of an order of the learned single judge, whereunder please winners, my plea for taking up the examinations
On the ground of
on the ground,
inadequate attendance.
plus that there are no sufficient number of students in that particular school. That is one of the reasons. It is yet to be de-recognized, please winners. It is an aided institution. There were 3 inspections conducted. 2 of them have gone in my favor. Examinations for 8th and 9th are commencing on 11th of this month, please, Manoj.
Your attendance is not adequate.
Plus, there are sufficient number of students. There is a court commissioner appointed. Court commissioner went to this school, inspected the property, and then has given a report that there are about 99 students pursuing their studies in that particular school. That has been ignored by the.
Yes, madam.
My lord, please take annexure and note, my lord, there is no recognition and the school has been closed from the academic year 2018-19 because the number of students were not there. And with regard to the appointment of the commissioner also, my lord, the person who had not been empowered had conducted the inspection.
179.
Annexure N to the writ petition, my lord, page
Page.
17.
not page 132.
132.
This is the endorsement that has been issued by the government. on 2/8/2018 itself, my lord, the recognition was not, the recognition was cancelled and that hasn't been, my lord, set aside.
It has been closed down from 2018 and. Bill admission.
Neil.
My lords, may kindly have a look at the court commissioner's report.
Bill admission, for which it is once again informed that no provision to recognize this. It may be granted. Continued school. No, there is no admission.
There is no admission. Then where is it?
Sir, Vinayak, sir.
Plus, the court commissioner appointed by this honorable court goes and inspects the property. On page number 185, your lordship may kindly have a look at. 185, please, Manoj. He submits a report after inspection. 185, please, Manoj. Class 8, 34 students, 9, 35 students, 10, 30 students, totally 99 students.
My lord, that official has been suspended. I have stated that.
It is the court commissioner, he can't be suspended at all by these
The report
persons.
that was given, he was not authorized to submit that report.
Court commissioner, there is no necessity of any authorization by the department.
Take paragraph 3 of my statement of objection at page 425.
In their presence only.
It is filed statement of objection.
My lord, students have been shifted, teachers have been shifted.
Laying out the report of the commissioner. Commissioner says there are 30 students in the 10th standard. Page 185. Report of the commissioner.
Whose report is there?
Well, let's see the court commissioner's report, please. Manoj.
Court commissioner.
On page number 182. Appointed by the court, please. Manoj.
In the presence of the department itself.
And in the presence of the department, the inspection has been taken place. The
Well,
department
today
of,
teacher is appointed as a court commissioner.
no, the
Court
teacher
commissioner
earlier,
means some advocate or
Well,
some other officers.
Mulas, it is advocate.
So
It
the
is
according to
advocate,
the
please.
report,
It is advocate commissioner, please, Manoj.
huh?
Advocate commissioner,
Advocate commissioner.
advocate commissioner.
He was advocate.
Page 182, please, Manoj.
Anirudh Kulkarni was advocate.
Please.
Who appointed? Court?
In court, please.
This court.
Yes.
In this court,
Appeal or in writ petition?
in writ petition. Writ petition number 16794 of 2023.
One letter complete instruction.
You filed your response.
Appeal and response.
My lord, for appeal, we argue the matter, my lord.
What do you say about this report?
My lord, that finds place in paragraph 11 at page 24.
Paragraph 11, yes.
The order
Further-
of the learned single judge.
On a single judge.
Yes,
Page 24.
this was the contention
Statement,
that was
bring
taken by
statement
them
of
even
objection.
before the learned single judge. Paragraph 11.
So this reported page 180,
190.
180 is referred to.
185.
Or, yeah, this is referred to in the order of learned single judge.
Yes,
Where is that?
paragraph 16.
15. No, it is not.
There are two reports.
They're referring
One
to
is
court
at
commission
paragraph
appeal,
11, the
16
other one is at paragraph
Action.
16.
Was enabled by the unauthorized person who was facing the departmental.
17 may be seen, my lord.
Annexure K is from by an unauthorized person and
That is by the official of the department, please.
And he has been suspended.
And he has been suspended according to them.
Yes. I have produced that as the next year R1 to the writ petition.
What is this report annexure, sir? Court Commissioner report annexure,
Annexure K.
annexure K. And then the single judge, learned single judge order says that the annexure K is by an unauthorized person.
My lord, there are two inspection reports. One is,
We accept the-
my lord,
Says that official report was the report which was liable to be believed.
Lord, one is 24/7/2017 at R3. The other one is, my lord, annexure K dated 7/8/2023. Paragraph 17 of the order of the learned single judge is also makes a reference to that. My lord, considering all these contentions that are being raised and were raised before the learned single judge, my lord, and the fact that the students and the teachers are no longer in the appellant institution, my lord, the order of the learned single judge does not require interference.
Was permission be granted to take the examination on 11th for 8th and 9th students? Well, I have no objection if an inspection is conducted tomorrow by another commissioner of this honorable court, please, honors. We still have students, there are teachers appointed by us out of the transfer of the government teachers, please, honors. The school is still running. There are students in 8th and 9th standards. They'll be deprived of the education, please, honors. And it is a rural area in a village. I have established a school, please, honors. It is a Kannada medium school.
We are not inclined, Mr. Counsel, to substitute we can't read appeal.
Now they are saying all the students have been shifted to some other school. ಇದಾಗ್ಲೇ ನೋಟಿಸ್ ಆಗಿದೆಯಾ ಮೇಡಮ್?
Notice it.
First time ಬರ್ತಾ ಇರೋದು.
It's coming.
Coming up for the first time, I'll take notice, there's no problem.
Take notice and post.
We will take. Leonard GA takes notice.
For all the respondents.
Well, it's 11th are the examinations, please. Coming 11th.
There is no recognition, I don't know how.
Plus recognition has.
No,
not
none
been
of the
passed.
students are before us, sir. Only the institution is coming.
Yes.
Plus the,
We have some.
Proxy. Even not a proxy.
Leonard GA takes notice to R1 to R4. So, nobody, they have to do what? Since the exam is going. Not the absence of the party.
After 4 weeks will be posted.
End of March.
23 allowed.
This month, last week of March.
Last week of March. March. Yes, 4 weeks.
Any date, March week, 4th. My end of the March.
28,
20.
28 March.
IA 3/23 early hearing allots.
Yes.
57 urgent, number 48. So YK Narayan Sharma.
Compromise.
Right, well,
Compromise.
yes, parties are settling the disputes.
48 compromise petition. Sir, the money of 5,40,301 paid, sir.
Yes, now we are paying. It's paid, Milord. It's paid.
So both are present.
Yes, sir.
Is representing whom?
Ramesh Patel, Raghuvanshi Timber and Sawmill.
Not Patel, Ramesh P. Patel.
Yes, sir.
You are another.
Girish Jain.
Girish Jain.
Girish Jain.
Girish Jain for
Appellant, Milord.
plan. Slip code here. Full stop. The representative of both appellant and the respondent are present. We revisit the IA 1/24, the compromise petition filed under R 23 rule 3 of CPC. Full stop. Both the representatives admits the terms of the compromise and DD, ICICI Bank DD.
Please,
Yes, sir.
DD number so and so para 2 null compromise ಇದೆ. So and so is handed over. Exchange. Full stop. Both agreed. The terms of settlement accordingly IA 1/24 is allowed. Consequently, appeal disposed of in terms of compromise petition. A refund of court fee is permitted.
Copy. Copy ತರಕ್ಕೆ. ಕೊಡ್ಬೇಕು.
For respondents in medical college.
This matter,
Disposal of.
That's, I'll file my objections, my lords. After disposal, this IA cannot be maintained.
my lords, this is, we have sought direction to the Director Medical Education, my lords, because this honorable court, already upheld the transfer approved by the NMC, my lords, because the 8th and the 9th respondents admitted illegally 150 students who approached this honorable court. And after hearing the matter, this honorable court upheld the approval, my lords. And now, my lords, out of 150 students, my lords, there was all these students were relocated to 24 colleges. And my lords, after that, my lords, now 130 students have been already admitted to the recipient colleges. Only around 24 students are not there. They have been denied by the recipient colleges on the ground that their fee is higher than the 8th respondent college. Therefore, my lords, we have sought direction to the DME, my lords, to intervene and direct these colleges. Kindly,
Now,
sir, my
madam,
lords.
their primary objection is that we can't expand the scope of the writ petition
No, my
because
lords,
a new
because-
cause of action.
Same order, my lords, wherein my lords have already upheld. Transfers have been made permanent, absolute. Therefore, my lords, we are asking direction to the DME, my lords.
Very short point here. It's a mandamus, they would have filed a mandamus petition.
See page 11, annex T2, that should cut short the exercise.
Sir, are the students.
This is only a consequential issue. Please see page 11, annex T2. At the bottom, noting number 2. The fees to be collected by the respective colleges as it was notified to the students at the time of admission at CR Medical College for the academic year so and so. Now pursuant to the direction of this court, all the other students have been admitted in the other college. They are paying the same fees, the notified fees. So if any of the recipient colleges
Fifth respondent should take it on this. Where is the fifth respondent? This is in some other matter.
ಕೊಡಿ ಇನ್ನೊಂದೆರಡು ಆರ್ಡರ್ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ ಇದು ಜಜ್ಮೆಂಟ್.
ಬರ್ತೈತಾ ಸೌಂಡ್?
The students cannot because they are paying whatever they are paying, my lords.
Now you are asking us to direct whom?
No, my lords, let the DME intervene in this matter, my
Private
lords. That's
medical
all I'm asking.
One
my
more
lords.
submit,
Kindly see,
one
my
more
lords.
once.
Kindly see, my lords. Page 11 is addressed by the
DME.
You are appearing for whom, sir?
Medical college, my lords. Well, that's my only, my
I
only
mean,
contention
you
is
are
my
appearing for medical.
medical college, GR Medical College. My lords, once
No, you are not say what is there.
the
You are
petition is disposed of, no, my lords, purely abusive process
GR
of law.
Medical College has no right of audience in this case, in this IS. You have no right of audience.
Can make one, sir.
We only between let the madam.
My
and
only
the-
submission is, my lords, let them file, it's a fresh cause of action, they should have come up
Mister,
with
you
a
have
new
no
IA.
right of audience at all because all the students have been shifted from you. So you keep quiet. Why
Please.
are you bother?
My request is, my lord, sir, this is the communication by the Director of Medical Education.
GR Medical. The director of medical, government advocate.
My lord, I appear for the state, my lord. Insofar as the DME is concerned, my lord, on 28/2/24 also, we have issued a direction to all the colleges to admit them based on the fees which they were paying in the previous college. Now, this list is only with regarding to the management quota seats and the fee fixed by them. My lord, that we are not aware of how much the
I have,
PR Medical College management is charged, that the KA has to answer. And if all are agreeable, then they will
What KA will answer, sir? You have to answer. You have passed the order. DM.
followed
Director of
insofar as the
Medical Education.
insofar as the management.
See that your order is accepted by the respective colleges in letter and spirit.
My lord, that this is with regard to only those 22 students who are being admitted for the management.
Read your letter. Page.
That is page T2, my lords, 11.
May I,
Read to.
T2, 11, page number 11 is by the Director of Medical Education.
may I produce the additional documents, my lord?
This last. Need to be collected as respective colleges is notified by the student time of GR Medical College of the academic. All
Lord,
the
I'll
incumbent colleges.
Pass on the additional documents, my lord.
Council of the Director of Medical Education Proceedings. We are for the spread of GR Medical College is accepted by the remaining.
Lord, may I request my lords to
These students are shifted in addition to the permitted strength allowed.
please
Excess, now they are in
excess,
excess.
excess. Lord, may kindly take page 9, my lord. The memo. Lord,
With your lordships kindly, my lords.
Advocate General.
With your lordships kindly.
Yes,
In fact, I'll call for a meeting between the management, the government and the institutions, my lords. Lordship may have it by Thursday, I'll sort out the issue, my lords.
Your
Because it's only a
indulgence
question
will-
of those students, I'll just call for the meeting and I'll just sort out, do it.
That is exactly.
I'll just,
That is, there is no order required in.
I'll take care of that. I understand, man.
After 10 days.
By Monday, or 10 days is good enough. I think it will be sorted out by then, man. Your lordship may kindly.
That is very fair.
Yes.
And
Full stop. Srimati Akadevi Learned Council for the.
no point wasting time on such matters. Man.
Learned Advocate General submit that the matter will be sorted out in a week. Can post after 10 days.
Your serial number 50 also similar.
All matters. 4950.
I appeal for appellant. I am not a party before the learned single judge of the Shamal Court. But my documents has been produced before the learned single judge. Without him looking into my documents, the order has been passed. Unless it is my sale deed which has been produced. Page number 128. Where I am not a party to the proceedings.
So what is the effect of the single judge order on you, sir?
No, I had been purchased this property and the very first respondent himself has filed a suit for declaration. Suit for declaration is pending adjudication before the civil court. Where I am a party before the civil court also. Now now I am running this educational institution in this property, my lord. Now he is trying to mutate the revenue entries to his name and to take the position of this property.
You are claiming under the Ramaya.
Yes,
Ramaya is the party in the writ.
no, he is a party. Where he had been produced my cell deed before the learned single judge of the Dismissal Court, Annexure L, page number 128.
Civil court.
Claiming under appellant, claiming under this
My vendor already sold to this property to me.
What is the civil?
Correct. So once the challenge to the settlement deed is negated by the civil court, then
Where settlement did, well, in 1952, settlement is between the, he is claiming respond number 5 and 6. That settlement is not between the 5 and 6. That is between the one Muniamma and Munikrishnappa. They are not relevant to this provision also.
but in this jurisdiction.
However, regarding the dispute based on the title itself, the civil suit is pending.
Then you work it out in civil suit, sir. You take a remedy and then go to the revenue authorities and get the kata restored in your name.
No, now he, based on this order of the learned single judge of the Sun, is trying to mutate this revenue entries, madam. Where I am running a educational institution, where I filed additional documents before the Honorable Court, madam. Where my documents are then. From the year 2016, I am running the educational institution. I had obtained all the permissions from the departments to run the educational institution.
Person from whom you are claiming is a party before the writ.
He has sold the property by the time itself, now. That has been not, but in the, my vendor has been not represented before the learned single judge of the Honorable Court, madam.
So rightly said that revenue authorities cannot base anything on the settlement deed which is negated by the.
Civil suit.
That is very simple.
Civil remedy.
Already civil suit is pending between them, between,
Pursue that,
till then not to precipitate this matter.
not pressing. Learned advocate, Mr. So and so does not press the present writ appeal. It is
Let the civil,
in the civil court.
You will work out the remedy in the civil.
You are withdrawing. Learned
till then
advocate-
this matter may, the order of the learned single judge should not be precipitated.
Learned advocate, so and so, 6 per. Wilson to withdraw the present writ appeal, stating that the appellant would take out the civil.
Why is number?
Take out the civil remedy in relation to.
OS number 1998 of 2006.
Already pending. Stating that
Still-
the suit number so and so is pending before the court of so and so, which shall be pursued by the appellant on merits. Full stop. Since the parties are at, since the parties are before the civil court in relation to the disputes between them, so on. We do not see any reason to entertain the present writ appeal. However, it is clarified that the suit shall proceed on its own merits in accordance with law.
Till then this order may be kept in abeyance.
How could you are not a party, that cannot be. You
Where
get-
my rights will be affected, madam. Where he is not
You,
claiming the right,
Get the early disposal of your suit.
where that suit is filed by the first respondent itself, not by me, madam. The suit is filed by the first respondent itself.
Here you work it out, sir. You go before the civil court for, seek for early disposal of the suit.
How can we say that?
Where he is claiming, where the first respondent is claiming for 1 acre, where his vendor having only 30 kuntas of land in it.
We have said that the suit will proceed on its own merits.
This order will be affected to me again.
This order cannot be given because you are not a party to the writ.
But where I am not a party for that itself, I had filed an application leave of the court to approach this.
ಬರೋದಿಲ್ಲ ಸುಮ್ನೆ ಮೆರಿಟ್ ಮೇಲೆ ವಜಾ ಆಗುತ್ತೆ ನೀವು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳೋದು ಬೆಸ್ಟ್ ಯು ಪರ್ಸ್ಯೂ ದೇಟ್ Pending IS disposed of.
Pending applications shall not survive in disposal of the matter.
Date, please give the date, sir, connected matter. Post along with
14th March, my lord.
14th March.
three, along with number so and so number.
23, WA 23. No, 3-4 matters. 3-4 matters are listed.
Interim order of the
58, 70, 70.
So it will go to some other.
52,
68, 52, 58,
68.
4 matters.
70, 78.
There are another 3 matters.
There are three matters are there.
Yes, 4.
70 and 70.
I may permitted take out notice for R1 and 2 minutes.
ಅಲ್ಲಿ ಅದು hearing ಆಗ್ಲಿ, but let the preliminary hearing.
ಬೇರೆದ್ರೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ already.
Notice already.
Already notice is already.
Old case ಅಲ್ಲಿ ನೋಡಪ್ಪ,
And
same.
there is an interim order for not to precipitate the matter. ಇದೆ.
ಬರ್ಲಿ ಒಂದ್ ಆಗತ್ ಬರ್ಲಿ, ಇದು let
ಅಲ್ಲ,
it come along with ಎಲ್ಲ everything, no interim order.
On the other matters.
Delay is there, delay of 71 days.
So in the identical matters, your lordship granted, you heard. In fact, relief is sought against the government.
Yes, there is.
Can they proceed in 1 or 2 cases?
ಇಲ್ಲ, ಮಾಡಕ್ಕೆ.
35 punch is there.
All the same.
14th will come
Identical order.
next week.
Good.
This matter is covered by the
This case I appear for
judgment
the,
of this honorable court, Lord. Following the judgment of apex court, in an identical circumstances, the prayers also same by verbatim, Lord.
May I make my submissions? Please?
Copy.
No, few things were not informed to this honorable court. I am aware of that. I think, in fact, I appeared in that matter.
JK Cement's case.
Yes, JK Cement matter. No doubt that this honorable court disposed of those petitions by following the judgment of Supreme Court. But the benefit that was extended to petitioners before Supreme Court was not extended. Because the notifications were held to be ultra vires to the extent that they collected, they levied the, either you speak, sir, or let me speak.
Please.
Supreme Court judgment.
Supreme Court. The prayers are extracted in that judgment, Lord. The prayers are identical.
Identical, one additional submission.
It is confirmed to Supreme Court.
Yes.
I concede, madam.
Then what additional submission?
That benefit should be extended to me. What they have, that's why a few facts may be necessary to appreciate this. The Supreme Court was largely concerned with the constitution of a fund called District Mineral Fund. By amending the MMDR Act of 1957, 2 sections were introduced, Section 9B and Section 9C. Section 9B introduced or provided for constitution or establishment of a fund called District Mineral Fund.
We'll put up this matter so that we can go through and better appreciate your.
Yes, ma'am.
Distinction. That is the only idea. When? Next week,
Next week, anytime.
14th?
Lord, I will, it is a word of honor. I will not go beyond what the Supreme Court has said.
We'll see.
Lord, I am just giving this judgment, which is not from any
I
journal.
have filed, my lord.
It is
The same judgment I have filed.
You have filed a copy.
I have filed a copy.
Which is that.
Anyway, let it be on.
This Madan Lokur said.
Yes,
Please,
please.
please.
Copy we have go.
Federation of Indian Minerals Industries.
Okay.
Presents not multiple, Leonard Senior Counsel for the petitioner, GF for so-and-so and DSG for the center.
Could it be on 13th, my lords?
13,
13th. Watch out.
13, 3.
Grateful.
55.
Well in.
Lord, sorry. In this, my lord, the state of Karnataka, my lord, has an act called the Karnataka Industries Facilitation Act. As per which, my lord, industries, my lord, there is a single window clearance agency, my lord, headed by the chief minister. Persons, my lord, who want to set up industries, my lord, like warehouses or, my lord, buildings for, my lord, industries, approach, my lord, the authority, this single window clearance agency, in which, my lord, the Karnataka Industrial Area Development Board also is a party. If my lords turn to, my lord, page 277 in volume 1, 278, my lord, in volume 1, volume 2.
Volume 2.
278. The project of the petitioner, my lord, was approved. Appellant was approved. 278 at 279, my lord. SHLCC 2.31. SHLCC approved in principle investment proposal of the company to set up integrated logistics and warehouse park industrial infrastructure at Chikka Alur village, Kasba Hubli. Investment is so and so. Land, my lords get, my lord, that, sorry. The land is, my lord, 163 acres. KADB to acquire and allot, my lord, as a single unit complex, my lord, that is without any, my lord, as land as it is, my lord, what is acquired. Pursuant to this, my lord, a government order was also issued. 337, my lord, has KDB, my lord, 376, if your lords has come to, my lord.
376.
Yes, ma'am. The land in, my lord, Chikka Hulur, my lord, please come to, my lord, 377, my lord. English translation, my lords get that at running, I'm sorry, English translation, my lords get that 379, my lord. Please come to, my lord, running page 380. In Chikkahalur, my lord, this much of land was given by the government to KADB for being allotted to me. As a single unit complex, that is, my lord, land as it is. This land, my lord, the government allotted, my lord, at the rate of 65 lakhs per acre. So, my lord, they should have given me at 65 lakhs per acre with, my lord, whatever, my lord, commission that they are entitled to, Karnataka Industrial Area Development Board. Notwithstanding, my lord, this allotment by the government for being allotted to me, they did not, my lord, issue me, my lord, a chalan, because without which, my lord, I can't deposit the money. Ultimately, my lord, I, my lord, went on requesting them. They did not give me this land. particular point, my lord, the powers that me said, my lord, that all right, we'll, you take 50 acres instead of 179. Even that I agreed, my lord, without prejudice. Even that, my lord, they did not, my lord, issue me the challan for, my lord, payment, nor did they, my lord, say that this is the amount that you'll have to pay. Ultimately, my lord, they give me a letter on 13/10/2010 and 20. 18/9/2020, my lord, at page 133 of the first volume itself.
Page number, sir, volume one.
My lord, 133. First volume. Government allotted to them, my lord, at 65 lakhs. That is what, my lord, they must give me. On the contrary, my lord, they are, my lord, now claiming, my lord, 2 crores should be paid by me. My lords get that at page 134. Cost of 47 acres of land of tentative rate of 2 crores per acre, 30% of the land cost payable initial deposit, so on so. Government, my lord, specifically allotted this land, my lord, to the KADBs for being given to me at 65 lakhs. So, my lord, they'll have to give me, my lord, at that rate. Instead of that, my lord, they said, my lord, you'll have to pay it at the rate of 2 crores. My lord, I challenge that. Learned single judge has dismissed it. My lord, I am before your lordships.
Annexure away, A was under challenge.
I, my lord, am willing to deposit, my lord, at the rate of 65. My lord, in fact, I filed one application also that, my lord, I'll deposit it before this honorable court. My lord, let them, my lord, the matter itself can be heard, subject to your lordship's convenience. I'll deposit at the rate of 65 lakhs per acre, my lord, for 50 acres. 58.5, sorry, not 60. Average comes to 58.5, sorry.
Per acre.
Yes, my lord. I'll deposit that amount before your lordships. An application also has been filed on 28/4/2023, my lord. 60. At the rate of 65, my lord, that is including their commission, whatever it is. I have filed an application. Permit me to deposit the entire amount, my lord, before your lordships. Hear the matter. Subject to your lordship's convenience, my lord, any time. My lord, 18th, 19th, I'm not in town, my lord.
Please,
21st, my lord, if it's not inconvenient to my lords, my lord.
please, 21st, please.
I think interim order is there, my lord, it has to be continued till the next day. Grateful to your lords. Please,
Please,
ma'am. Grateful.
For the appellant. Appearing for response number 4.
I'm appearing for response number 2.
So in the connected matter on Friday, your lordship were pleased to issue notice, my lord. It is arising out of common order. Yes.
They are the common, we will club all together.
No, this is only one. Only one.
Already 56 and sir, Datar sir.
Please, my lord.
Only 2 matters na.
Yes, these two.
They both club.
6 and 56.1.
Yes.
Please, my lord.
And 56.1, my name has to be shown for response number 2.
It's already shown, sir.
Yes, in 56, there is no, my name is not being shown.
So where 56, we have to show your name.
Yes, and my request is petition may be directed, the appellant may be directed to serve the copy of both the writ appeals.
Certainly, I have to do it.
Yes.
State GA takes notice to R1. You are for case TDC, sir?
Yes, sir.
The Guraj Joshi takes notice to R2. Joint Commissioner Transport to Vice.
My lord, I take notice.
1 and 3. GA takes notice to 1 and 3. 2 for Guraj Joshi. And airport.
I appear for the response number 4.
ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ ಗುರುದೇವ್ ಗೌರವ್ ಮಂದಪ್ಪ takes notice to R.
My lord, on Friday, my lord, the Chief Justice wanted to know whether there was a scheme with regard to the agreement that had been entered into by the Karnataka State Tourism and the Bangalore International Airport. My lord, there is a scheme that is called as a city taxi service scheme.
And you get that?
Yes.
So, we'll produce it because, and also applicability of it to this, because it is within 25 kilometers, it restricted. Whether it can be, whether it is still continuing.
Is requested, sir, the one set of copy to the other.
Please, my lord. I'm grateful.
Copy, sir.
I will answer all the contentions. Since the scheme itself is not being challenged,
Yes.
scheme itself is not being challenged by the petition appellant in the petition.
I'll
That is
submit, my lord.
specifically contention has been taken.
Anyway, you get the copy of this.
Yes, then I will assist my lordship.
Please, my lord.
The scheme has been produced, my lords, along with the report.
Yes.
So when is it posted?
25-3.
Copies, thoroughly. Please take the copies. Sir.
Yes. Much.
Lord, land reforms matter. From South Canara, many parties are governed by the Aliya Santanala.
The Chaitanya Agri, Learned Council for the appellant, because GA takes notice to R1, notice to R2 to.
Some of the R5A is the only contesting respondent. Other respondents who had, were served were not represented. They did not participate in the proceeding. I am seeking for dispensation of notice to.
Council for the appellant files memo seeking dispensation of notice to R2A, 2D, it is an up to R4D memo, full stop. Memo placed on record. Notice to R2A dash R4D is dispensed with at the risk of the appellant. Issue notice to other private residents.
And I sought for stay of it.
Delay is there.
Delay is because the review was pending.
Delay is no interim stay. Let the service complete and then you ask.
What I'm saying is, the delay is because the review was pending. So under.
If your delay application dismissed, appeal goes.
I know, I mean, keeping it open, the delay point, because.
No, irregular appeal, no.
There was any. There was an interim order in the writ petition also. Obliged.
15th April, seal number 58. Appeal by government.
I appear for the appellant. My lord, respondent number 1 was the ex-Shanbog, my lord. After the coming into force of the Karnataka Land Revenue Act, they were called as village accountants. My lord, a batch of applications had been filed by Shanbogs and Patwaris. My lord, they are seeking for grant of pension. My lord, they are seeking for interest on the pension amount.
Only the government has since they have related for. Yes, madam.
There is, my lord, and the rules were relaxed. Karnataka Civil Services rules were relaxed. And my lord, the interest was paid to them on the penalty amount, on the pension amount. My lord, similar orders have been passed.
Yeah.
The latest being, my lord, it's as per annexure J, my lord, page 121. My lord, my delay application. Yes, that's it.
Yeah, 1 of 23. Yeah. 40 days.
My lord, I'm sorry, my lord, it's not. Huh? I don't know.
2022 litigation officer is appointed.
There is, they have said 640 days delay.
Clearly saying administrative reasons without elaborating it.
My lord?
Clearly saying that it is administrative reasons which is.
No, I leave it to my lord.
Nothing elaborate. Dismiss.
Obliged.
Consider.
December 59. Gopal,
This case, my lord, similar, identical matter, my lord, this court has ordered notice to the respondents, my lord. Kindly order for notice and matter may be clubbed along with the writ appeal number 1390/23.
What is the connected appeal, sir?
Connected appeals number 1390/23.
Zip code number is. Council for the, so you are for KDB.
Yes, my lord.
Council for the appellant submit that there are connected. Issue notice. GA takes notice to R4.
Yes,
And notice to R1. to
kindly permit me to serve a copy of the appeal to the learned advocate who has represented in the.
Ordered to serve the copy to the council appearing in the writ also.
Yes, ma'am.
Supply.
All along with so and so number.
seal number 60. Shri MC Basuraj.
MC Basuraj.
Shri MC Basuraj. Nitecha Renuka.
None appears. 4 weeks.
27/5. Seal number 60. 61. Keshav Bhatt.
Kindly pass over, my lord. Yes, kindly pass over, my lord.
For the commissioner of the amendment of Rule 20.
Please.
Number 62. Surely.
Yes, brother. 62 in the first matter. 62 in the first matter. Not Vengesh, not services of senior counsel, Mr. Not Panindra. It is held up in our court. Kindly pass over. It will come up.
My submission, my lord. For the last 2 years before my lord's here, my matter is fortunately or incidentally tagged with serial number 62, wherein he is not a quarry license or leaseholder, whereas my 3 cases, I am the quarry license holder of Patal and my lords. Because of this tagging with that matter, it is never being heard, my lords.
But I am sorry that he may be heard. Let him make his submission.
Yes, if
But
I,
the issue involved in all the cases are one and the same. He has also challenged the virus of the rule. I have also challenged the virus of the rule. Not his anxiety is his matter to be heard first. Not unnecessarily he is not he's making submission. My matter is let him make submission.
Mine.
In the
matter
meantime,
may be-
senior counsel will come and
Mine
my
matter
case.
may be heard, my lord. That's what is my submission.
They are ready to address the argument, pass over. But let the Panindra, our senior, let the learned senior. counsel.
No, it is independent, my lords. The position of law gets totally
That's it,
changed
sir. If we
because we don't
understand,
have
then we will
access.
detag, we will think of.
But it is not fair on his part. Kindly, there is the prayer of his writ petition and my prayer writ petition.
Please, my lord, it may be detagged and I may be heard, my lords.
Pass over.
Please, my lord.
Number 63. Mr. Shivarajan Reddy.
Lords, in this matter, morning, that's we had made a request. This matter may be connected with serial number 77, and that's may grant me 2 weeks' time. That's we are arriving at a solution, that's which will benefit the petitioner itself.
Millards, we have until then, Millards.
That's I've been, that's in the last date also, I was told not to instruct my officials, and I've done so, Millards. Let there be no record.
May I request Millards to grant
I've served copy minutes.
He's just served a copy on last week. Minutes, we are arriving at a solution to solve his problem itself. Minutes, without getting into it.
My lords, there are a lot of problems with the industries being faced at the hands of pollution. Please. Yes, my lords. Please, my lords. Let them not precipitate until then.
That's, I'm only saying that.
Interim order may kindly be granted. Until then.
That's my lords had instructed me. That's that I should be instructing my officials not to take, and they're doing so much. That's 2 weeks back, the matter came up. 1 week back, the matter came up. That's still today, nothing has happened. 2 weeks, nothing is going to happen. That's my assurance to the court.
But page 55 is the order which can be followed.
Let's mimic the submission. What was passed that day, Millards, that based on which this order came to be passed, came to be Millards, answered another writ petition saying that Millards, this is not a correct order. Now, Millards, what has happened is there are a set of review petitions which are pending, which the petitioner has only filed it, the petitioner's counsel. That's we are at a verge of, arriving at a solution. That's all these environmental compensation cases, that's before your lords, and all other courts will be closed at once.
My lords, is that the authority cannot at all issue such a demand notice, my lords, because jurisdiction itself is not there, my lords, under NGT Act or nor even Water Act, which provision authorizes them to issue such a notice, my lords, for environmental compensation. If my friend demonstrates before this honorable court, Water Act, Air Act, and Environmental Protection Act, NGT Act, my lords, any specific provision to authorizing them to issue?
That has been answered by this court. That's the only.
My lords, your lordships would see.
The only issue which should be pending before my lords is that whether we should be giving them a notice before imposing the environmental compensation. And that is exactly what my lords have, my lords, at Annexure C1 is the order. Give them a notice, then go ahead with it. That's that itself, this order, my lords, on what it got relied upon. Another division bench, my lords, by the learned Chief Justice, my lords, deferred with it, saying that, my lords, that order was not in accordance with law. So, my lords, we are trying to arrive at a solution for the petitioner. 2 weeks, my lords, nothing is going to happen. Now, my lords, yes, my lords, the order, my lords, which is at page number 39, which is Annexure C. There was an erroneous submission made, my lords, without instruction by one of our counsels, my lords, that we do not have power. That is the strength on which the petitioner is coming before this court. Page 39.
Relevant,
page 39, my
relevant
lords,
page is
may look
52.
at.
52 is the
That's may looked at. 39 is the starting part of the judgment.
batch of
my lords.
petitions.
At page 52, my lords, a question was posed to the counsel for the board. Do we have any powers, my lords? Without instructions, a concession was made. My lords, this judgment, my lords, has been looked into by another bench where they said that, my lords, we do have the power to impose. Now that would be res integra. We don't have anything to discuss on the authority. Now the only question, my lords, which would arise is whether we have to give them notice of show cause hearing before we impose. I'm only seeking, my lords, 2 weeks' time.
Solution, if they give the solution, there is no.
This may be tagged along with serial number 77. my lords. And then that may, I've informed the senior counsel was appearing in this matter in that matter also. We will surely, my lords, solve this issue of environmental competition.
Legal issue, my lords. There is no such directions as observed by this honorable court way back in March, be it interim or final. They are not empowered by statutory power.
You will take notice for, you are not filed the wakalat.
We already served a copy, my lords, that may kindly be
We will
recorded.
do that.
And notice last time, you filed the
Yes,
wakalat.
yes.
Stop. C.S. Mahesh Chaudhary, learned counsel for the respondent. Seek 2 weeks time on the stating that the respondent is bringing some solution to the issue in question.
My lords, interim order.
On 2nd of April, my lords.
2nd of April.
2nd of April.
They are making a statement that they are not precipitating the.
My lords, 5 crore, my lord, there are a lot of
77,
consequences which
serial
flow.
77.
Therefore,
We have-
interim order until then, my lords, otherwise. In 77 also there is a interim order.
Well, the July 2023.
My lords, in 77 there is a interim order.
That will be extended.
And in the 63 it has to be
I'm saying
granted,
it's
my lords.
connected.
Same.
There's no interim order there, my lords. I would respectfully submit, it was my statement, which my lords was recorded. I'm saying that, my lords, this order which is being challenged is 12th July 2023. My lords, we are 7 months or 8 months down the lane. Nothing has happened, my lords. 3 weeks, nothing would happen.
It's filed on September 2nd itself.
We will do that, my lords. We won't take any coercive steps.
Is observed in order dated 22/24, their pollution board.
Yes, my lords.
Pollution board shall not take any precipitative action is extended.
That is there in 77, my lords. In 63, it has to be granted.
It's connected. Same thing, my lords. We were not doing anything, my lords.
Same order may passed in 63.
ಅವ್ರು ಅಷ್ಟೆಲ್ಲ ಹೇಳ್ತಾ ಇದಾರೆ ನೀವು ಈ ತರ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ಆಫೀಸರ್ಸ್ ಬಂದು ಅಲ್ಲಿ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಸ್ವಾಮಿ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಡಿಸ್ಕನೆಕ್ಷನ್, ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್.
8 months ಇಂದ ಆಗಿದೆ ಸ್ವಾಮಿ.
Please.
Grateful, my lords.
As your lordship, as your.
In the matter where it is filed, will be extended. There is no fresh order.
Grateful, my lords.
Until then, what hanging sword, 5 crores, my lords, 25 lakh rupee would be the investment, my lords. 5 crore and not exorbitant arbitrarily.
There's the damage caused to the environment, my lords.
If it is, that is the appropriate forum, not like this issuing a orders at the threshold and harassing the industries.
See, the tenor of submission says that they will not going to do it.
Please, please.
Number 64, Joseph Anthony.
For the petitioner, my lords, we filed this petition seeking some clarifications with respect to two separate acts, my lords. That is the Karnataka Apartment Ownership Act and the Karnataka Ownership Flats Act. My lords, certain provisions of both these acts read together cause for some lacuna and difficulties in the registration of apartment ownership, apartment association, my lords, owners associations, my lords, the registration as well as the operation, my lords. So now we have filed this petition seeking for clarification in respect of what the actual procedure for the registration of such apartment ownerships.
I appear. My lord, may I make one submission? My lord, the prayer may be seen, my lord. It is a mandamus to respondents 1 and 2 to consider the representation dated 10th April 2023. Now, respondents 1 and 2 are the chief secretary and the principal secretary law. My lord, the representation may be seen, my lord, which is at page 22. My lord, this is
28.
addressed to the respondent number 4.
Page 28, my lords.
My lord, and there is no, my lord, endorsement to show that this has been submitted even to the fourth respondent.
My lords,
They are seeking for a mandamus.
my lords, at page 29, my lords, a copy of the said representation was addressed to all the respondents, my lords.
I don't have.
These were issued by registered post itself. my lords.
Acknowledgement, sir.
My lords, we shall file the acknowledgement for having issued them by registered post.
My lord, it cannot be. There should be a demand and there should be a refusal. There is no demand at all.
Let them make a representation.
Can make fresh.
A fresh representation. My lords, the cause of action would remain the same, my lords, if direction may be given to issue a fresh representation on the same point. My lords, at page number 19, my lords.
And that too a positive direction, my lord.
My lords, said question that has been raised in this petition has been raised. My lords,
You are the owner of apartment.
Yes, my lords, and the petitioner has also held the position of president in various apartment ownership associations as well, my lords. The question that is raised in this writ petition has been raised before and prior in other writ petitions as well, my lords. If my lords, if I may kindly turn my lords' attention to page 29 of the representation itself. At paragraph number 2 at page number 29, my lords. If I may just read that out, my lords. Meanwhile, the matter has gained considerable significance now with the Honorable Supreme Court of India giving deadlines to states to submit their views in the matter, and a link has been provided by the petitioner, my lords. The preceding paragraph, my lords, as it is, there already are connected cases in WP number 10669 of 2019 and related WP number 511 of 2019 and WP 7276 of 2019, apart from writ appeals that are pending. My lords, the question that is raised and already
Don't have this information at all, my lord. My writ petition is not complete.
my lords, the procedure for registration of apartments ownership association, my lords. Now, both the acts that are questioned here in my lords, that is the Karnataka Apartment Ownership Act as well as the Karnataka Ownership Flats Act, my lords, provide for different regulations for the registration of apartment ownership association, my lords, or owners association, as the case may be. There is no clarity as to what the procedure is to be followed is, as well as what the authority before whom such a registration may be done. There are multiple options that are given as to registration as a company, as a cooperative society, or filing of a deed of declaration with the registrar of societies or the sub-registrar revenue department. When there is no clarity that is being given, my lords, it has become difficult for the apartment owners and owners association to register. Indeed, my lords. My lords, if an opportunity may be given to clarify on these points, my lords. I bow to that, my lords. I humbly pray that an opportunity may be granted, my lords.
Such a vague petition, like you know what, like.
My lords, pardon, my lords.
Very general.
Making general reference and general comments.
My lords, the lacuna, as I explained, my lords, as I submitted, my lords, is that the process for registration, as well as the rights of an association that is registered or to propose to be registered between these two acts, as well as the RERA Act that has now come forward, my lords, is very vague. There is no proper procedure that is being provided for within the acts itself, my lords.
You have made any efforts to register the association?
We have, my lords.
Where is the
Now,
documents? Where are those documents? What are the efforts made?
my lords, this is a public interest litigation that has been filed in favor of all apartment ownership owners, my lords, not in general of a single cause of action of the petitioner alone, my lords.
Child as public interest. It's not claiming to be a public interest.
My lords, if an opportunity may be granted, if it may be passed over, my lords, I humbly pray that the opportunity may be granted for my senior to address this honorable court as well. My lords, if I bow to the fact that I may not be able to give clarity to this matter as well as my senior may be able to, my lords. Hence, I humbly pray that the opportunity may be granted. Obliged, my lords.
Tomorrow?
Please, my lords.
Tomorrow, let's get.
Grateful, my lord.
Tomorrow, no time.
I bow to that.
We'll be taking up after that one.
First, serial.
Serial 3, top of the list.
Obliged, my lords. Grateful.
Number 65, Avinash Loda, GS.
The order under challenge is a connection A, my lords. It's a matter relating to the quarry lease, my lords, which was extended on a dias non-period. There is a dispute whether it's a forest land or a non-forest land. My lords, this lease has been in existence from 2001. An endorsement was issued by the senior geologist, which we challenged by filing a revision. The order, impugned order, is the revisional order at Annexure A, my lords, which your lordship should get the English translation at page 41 onwards. Now, my lords, while rejecting the revision, The revisional authority goes into issues which were not even raised. My lords, the revisional authority only exercises limited powers of revision. That's page 41 is the order, impugned order at page 41 onwards. What was challenged was an endorsement issued by the senior geologist, my lord, suspending the quarrying or refusing to issue permits. There were other endorsements which are interdepartmental communications by the forest department, not contending that these are forest lands and the permit should not be issued. Now, while considering my revision, please see page 45. Revisional authority, that could not, my lords, it's not even my contention. No one raises that. He could not have gone into the validity of the diasnon in a revision where I had challenged something else. In fact, while issuing notice, this honorable court has recorded that issue itself as an issue that has to be considered by this honorable court on 8/11/2023. And this is a lease which is in existence from 2001 onwards. That page 43, your lordship should get second para, unnumbered para. He says because it's an interdepartmental communication, so far as forest department's communication, that can't be challenged, but that is made effect put against me to stop the quarry. And thereafter he proceeds further at page 45 onwards. That's an issue which I was not even put to notice. My lords, if suppose it was an illegal thing, the granting authority has to take action. Now, my lords, in fact, this diasnon period also pales into insignificance because, my lords, in 2023, there has been an amendment to the rules which grants an extension of lease for 30 years.
Yes. On 27th November 2023, I filed.
Yes, already filed. Second one.
Yes.
The request is, please. Notes.
18.
Specific date. Because I have given an undertaking, I will not carry on mining for him, that's the only reason.
ಅದರಲ್ಲಿ 65 ಅಲ್ಲಿ presents not much. Hand over to 18. 130.
Feedback है. Pass over, pass over.
Appearing for the appellate. Sorry, my lord.
Is it possible to keep a door open?
I'm sorry, my lord, for. But in 1958, 30 acres of land, my lord, was leased to this, a church actually, it is running education institutions also, my lord. They are their orphanage and all that. 30, for cashew cultivation, it was granted. Lease. My lord, under the rules, my lord, after 30 years, my lord, they are entitled for grant of it, provided they fulfill the terms of conditions of grant. Accordingly, they applied and it was granted also. Kindly see, my lord, the grant order that is at Annexure B. My lord, the deputy commissioner has granted it based on the report and all that. There is no dispute. Translation is at Annexure B is the Annexure A. I'm sorry, the grant order, it is in Kannada. My translation is at ink page 20. Ink page 20. As per number so and so dated 5/9/58 of the Tahsildar Karkal, an extent of 5.55 acres of land situated in survey number 308/3 of Nara village, Beltangadi Taluk was given on tenancy for cashew cultivation to Reverend Father P. Fernandez for a period of 30 years. In the report dated 15/2/94, submitted by the Assistant Commissioner Puttur by conducting spot inspection, it is reported that Reverend Father Fernandez, the parish priest of Saint Anthony Church, has been running an orphanage with an intention of provide quality education to poor, orphaned, and destitute children of the neighborhood and far-off places. There are about 236 crop yielding cashew trees in the said lands which have been kept in a very good condition. There are more than 40 cashew tree in 1 acre that new saplings have.
After this order, tribunal passed the order.
He said, my lord, you have to pay 12,000 rupees per acre. That was the grant order. But I went to the KAT, my lord, saying that this amount is a little more, kindly reduce it little. We made a request, they refused, and that is why we went to the KAT. KAT, my lord, allowed my appeal. Kindly see, my lord, ink page 27.
27.
Last portion,
Yes.
27.
Yes.
27. In the result, the appeal is allowed. The impugned order passed by the respondent relating only to the amount fixed and payable in respect of the land in question is.
That amount is reduced now?
But they have not passed any orders.
Any order.
Therefore, I filed a writ for mandamus.
So you file writ petition.
But learned judge says, my lord, you give a new representation. That defeats very.
Allow the prayer and the writ.
This rule.
Application date 8th March 23, Rule 23.
Rule 23, which has come into only on the other day, much later, which has no application as far as this is concerned.
So this,
that is my submission. Now, this is, my lord, subsequently, now there is a fresh rule and all that.
So learned single judge has relegated you to the jurisdictional commissioner for the purpose of amount or for grant itself?
For grant itself, my lord. Now, to make an application.
Relief that is sought for in the writ petition, my lord may see the relief in the writ petition. Page, my lord, page 14.
Page 14.
Yes.
Page.
In the copy you've given to me, it's page 14, sir.
The prayer is based on the order of the tribunal and the earlier order of grant.
Yes, but the prayer he is seeking for is to issue a grant certificate. Grant certificate has been issued. It is issued subject to him paying 12,000 rupees, my lord. So they had asked for reduction of that amount.
No, no.
They
no, no.
don't seek for reduction.
Two things are different, reduction of amount and grant itself.
Yes.
Now order at page 20 annexure is final or not? As far as grant of land is concerned,
That is final.
that is final. So why don't you grant it and determine the amount? This amendment appears to be much later in 23.
That is March 23, this amendment.
But, my lord, the prayer and the writ petition may be seen. Based on that, the learned single judge has passed the order. I will take instructions now with regard to what has happened and may come back to my lord.
We will not grant the prayer as it is made, but the order at page 20 is not wiped out.
It's not wiped out, but the relief that they have sought for in the writ petition is what the learned single judge has considered. My lord may please see the prayer in the writ petition.
Therefore, Ms. Counsel, this order at page 20 itself is a order of grant of land.
Grant order is there, my lord. They should have sought for this amount as per the order of the Karnataka Appellate Tribunal.
The prayer may not be happily worded, but
Very well. Then my lord may grant me 2 weeks' time, my lord. I'll seek instructions and make my submission. Because I don't know what has happened.
no, only thing that whether you can apply the amendment to relegate him to some jurisdictional commissioner when the order is already final. Up to the tribunal.
Prayer is correctly made. Certificate, my lord, they have to issue separately, grant certificate.
If they are granting you the land, why don't
Very
you
well,
say
very
that
well.
prayer is not correctly?
Very well, very well.
Unless you pay the upset price, they will.
I understand.
Precondition of payment.
That is their lookout, whether to reduce the price or not.
They have some, my lord, we have given it to them on an upset price of 12,000 rupees. They found it to be a little exorbitant and they went before the Karnataka Appellate Tribunal.
Correct.
My lord, there they said you reduce it. Now they have come back and now based on their prayer in the writ petition, the learned single judge has relegated them back to the assistant commissioner. I will seek instructions and make my submission.
That is doubtful subject to what you submit.
Very well.
Very well.
We will keep it on 13th of May, 13th of March.
My lord, 2 weeks, my lord, because
will be-
8th, 9th is a holiday.
So you're counting holiday.
My lord, I won't get instructions, my lord. That's the reason why.
March, 19th March.
Obliged.
Okay.
On holiday you don't work.
My lord?
Holiday you don't work.
No, no, officers don't work, we work.
Officer
my lord.
don't work. They'll receive your phone call. Don't take it seriously.
No, my lord.
I'm a habit of,
My lord, it's a pleasure to appear before my lord and I would.
Not 62, my lords. Sorry, I was not in the morning. This is an order which is challenged, is an endorsement issued by the Deputy Director of Mines and Geology. Or is endorsing that the claim for grant of quarrying lease in respect of laterite cannot be granted. That's the issue, my lords. At Annexure H, page 79 is the impugned order. And the Deputy Director relies on a threshold value notified by the Indian Bureau of Mines for bauxite and says that the land in question contains certain aluminisa laterite. Laterite is a minor mineral, my lords. Bauxite, my lords, it's like this. Bauxite always has laterite. It's a component. But my lords, laterite has been made as a minor mineral. And what the Deputy Director says is he relies on a threshold value notified by the IBM, Indian Bureau of Mines, my lords, for bauxite. The threshold value, purpose of my lords, notifying the threshold value, that is, my lords, different components of chemical in a mineral, is that if the threshold value is less than that, it is considered to be a waste. That's the only issue.
Considered to be a waste.
Waste, my lords. It's not no use for purpose of exploitation. Now, my lords, for laterite, there is no threshold value notified at all.
So what is
So
your
he could- My lords, annexure H is questioned at page 79, along with this. If your lordship kindly comes to page 79, my lords. That's the order date endorsement, or it's an order, my lords, though it's filed as an endorsement. 17/11/2022.
What way it is ultra virus?
My lords,
You are saying it is ultra virus?
my lords, this endorsement is ultra virus because two things, my lords. He says the aluminous laterite is less than so and so, and referring to a threshold value notification by the IBM. The IBM notification your lordship should get at page 84. Please come to annexure K at page 84, my lords. In that, for bauxite, they have given the threshold value, if your lordship sees 84, my lords.
Laterite is not mentioned.
Aluminous laterite. Laterite is a separate mineral, my lords. That's why I said, my lords, like laterite is every bauxite has laterite in it. It's a accepted norm in the, but my lords, laterite is a separate mineral which has been classified as a minor mineral. Now this threshold value, which is at annexure K, the central government issues it only for the purpose of mineral evidence of mineral contents rule 2015, which sets out that anything less than a threshold value, it is known as a waste, my lords. Suppose, my lords, I have to exploit bauxite.
So this laterite is shown to be below threshold value?
No, bauxite is shown. My lords, that's the problem. Laterite, they have not fixed the threshold value at all. That's an admitted fact.
Not fixed at all.
There's no fixed laterite. For laterite, they have not.
Then why do you worry?
No, they have rejected my application by referring to the threshold value fixed for bauxite. That cannot be done is our
But then this laterite is classified as separate minor mineral.
Yes, it's a separate minor mineral.
To be treated, on all respect, it will be treated separately.
My lords,
All purposes.
these are, my lords, for major minerals. The notification at annexure K is a major mineral. All these minerals, my lords, bauxite, others are all major minerals.
What is page 89?
89, my lords. Yes. Laterite is a minor mineral. So that's why I have applied for a lease for laterite. The department, my lords, rejects my application referring to a threshold value of bauxite, which cannot be done.
What do you say, Mr.?
Not, even for laterite, threshold value is fixed by the IBM. Kailash may kindly peruse page number 84. Serial number 2. Under bauxite only, not 1. For aluminous laterite, it is 20% minimum. But this earlier laterite as well as bauxite together considered as major mineral. Only in the year 2015, laterite has been classified as special minor mineral. Now, Lord, we have prescribed the royalty to be paid for this laterite under Schedule 2. We have filed a detailed statement of objection, Lord. Your Lordship may kindly take my statement of objection.
The central government has filed its counter. Central government has said it's not.
Lord, my first, before going to that, Lord, challenge to this very large schedule itself is not maintainable. The applicant is only, the petitioner is only an applicant, Lord, in this matter. He has not been conferred with any right over the mineral, either by way of grant of quarry license or grant notification. Lord, in order to avoid the statutory remedy, they invented this method to challenge the schedule to the rule. without challenging the rule itself. I have extracted that rule, my lord, in statement of objection.
No, that we have questioned the schedule to the, for the purpose of royalty, how they have classified royalty, which is wrong for laterite also. It's not an invention.
Your lord may kindly take my statement
Your
of
Lordship,
objection.
the central government's counter what assumes importance because it's the authority which has issued the threshold value
Now,
and they
since
say.
the endorsement issued by the state government is challenged, my lord. Challenge is to the various of this particular schedule. Last may kindly go to page number 12, wherein Lord I have extracted rule 36.
So which schedule to be seen?
And
Schedule
Schedule
1C?
2, if you allow.
schedule 2.
1C, 2.
Yes.
Schedule 2, yes.
Serial number 33 is laterite, no? In schedule 2. Schedule 2 is under Lord rule 36, sub rule 1. In that book, Lord, it is in page number 164.
So this below or above threshold value will determine the rate of royalty.
Yes, please.
Now threshold value, the central government notifies. Please see the central government's
The
counter.
IBM is the authority.
Yes, they have filed their counter.
IBM is the authority which specifies the threshold.
But then,
well,
Mr. Mahendra, you were showing this, which page you showed?
That's the
Showing that
schedule. which-
laterite is taken care of
Yes.
in that.
That's annexure K at page 84.
84.
Yes.
84.
Now the schedule entry and this doesn't go together.
Lord, this is the notification issued by Ministry of Mines, Lord. Ministry of Mines. Lord, may kindly see. IBM through notice published in website.
So according to you, this notification at page 84
Please,
mentions
the
the
threshold value.
threshold value of laterite.
Yes.
And the entry in the schedule says that it is below. So both don't go together.
Lord,
It's only one. Central government, which is the author of this notification.
Is it correct?
No, because central government, which is the author of this notification, has filed a counter in this
Not-
rate. And they have specifically said, we have
Yes.
not notified threshold value under this notification also for laterite. That's their counter. In this writ petition, central government is the author of this notification.
Lord, may I make submission?
Aluminous laterite is same as laterite.
No.
Ah.
Lords, it is not.
Aluminous-
With great respect, it is not.
It is, Lord. Aluminous laterite is, Lord, below the threshold value. What is stated in schedule 2 is, it is below the threshold value.
Then here you are providing some threshold value.
That's
20%, Lord, minimum.
Percent. Yes.
Minimum, it is mentioned in the bracket minimum.
Below, not below. It is prescribing, not below. It is threshold value.
Lord, your last may kindly appreciate. For aluminous
So
lat,
we are not expert. We are not able to reconcile the two. Page 86, 84 and the entry.
Schedule 2.
Lord, this has been considered in one of the judgments also. by Kerala High Court, my lord, which learned friend.
I know, they have said they have not notified. That's what they said. In fact, my lords, may I
That is
just
altogether
request your
different.
lordships to see the
So far-
counter
Yeah.
of the central government, my lords. That would probably clarify. In fact,
May,
central government is a main authority which has to answer this issue more than the state. Because they were the ones who, my lords, classified it as a minor mineral, and it is the authority which gives the threshold value.
We are trying to understand, but then as far as you are concerned, what kind of right you are asserting?
My lords,
What is
these,
the
my lords,
nature of your right?
no, these are private lands, my lords, which owned by us. Now, I was carrying on the quarrying for, my lords, laterite. Thereafter, it was cancelled. Then I applied for a quarrying license in the land. Their rejection is that this mineral is not laterite. They only refer to this notification and says it is below the threshold value. So I have come and said it can't be that. The rejection is only on that.
You are excavating this
Laterite,
bauxite.
not bauxite.
Bauxite or laterite?
Laterite. I was always
Which is part of bauxite.
My lord, that's why I said bauxite always has laterite.
So you, unless you excavate bauxite, you can't excavate.
No, no, it's not like that. My lord. It does not work like that. My lords, it does not work like that, my lords.
Not able to catch.
No, no, my lords. I understand what your lordships are saying is actually I am extracting bauxite, but I am saying it is laterite. That can't be, my lords, because that's why for bauxite, when they give the threshold value, they say aluminous nitrate minimum 20%. And, my lords, the aluminous nitrate and sodium thing should be there. These are the components which make it. Otherwise, my lords, that is the difference in anything. Otherwise, the government, my lord, central government would not have declassified and made laterite as a separate mineral. It is classified as a minor mineral. Otherwise, my lords, there can't be any bauxite at all or laterite at all. I had given last time, my lords, on IBM's history on what bauxite is. Otherwise, my lord, there was no necessity of, if your lordship reads the IBM's history on bauxite, how bauxite has come, it shows, my lord, it's like this genus and species, my lords. Like, my lords, a dog is an animal, but not all animals are dog. That's the basic thing in this. The central government has to answer this.
May I take your lordship
But
to?
if your lordship just sees the counter of the central government, my lord, that would make things clear before anything else, because they are the authors.
Ultimately, it is for them to prescribe the.
Yes.
But they have not prescribed the threshold value.
They are not prescribed.
Then, my lords, without the first, my lords, there is no threshold value, you can't reject it on a notification issued by central government. What they do is they refer to the central government's notification and say threshold value is mentioned there. That is only for bauxite. So when I apply for laterite, you can't use that.
You are for central government.
Yes.
What is yours?
Yes, my lord. It is a minor mineral, laterite is a minor mineral. It was not notified and it cannot be taken into as a bauxite. In the second matter, I filed the statement of objection. Second matter.
17.
Same stand.
17 to 87.
Yes.
Not in the schedule.
First, tell us, what is the significance of what is called below threshold value?
That is explained in the rules. I can take your lordship's threshold value.
Where it is explained?
Lord, in
Lords, please
para
come
9
to
and 10,
under the rules.
In the para 9
minute.
and 10 of the statement of objections, I have explained that.
Lords, it is
Page
found.
7 of my counter.
7.
Please come to the rules, my lords. There it explains what is a threshold value. Evidence of mineral contents rules.
Para 10, my lord, it is relevant.
So it is treated as minor mineral.
Minor.
And accordingly, this 20, below 20% is prescribed.
Below 20% is minor mineral, that is laterite. And in further it is stated, my lord, in
If it is
para
20
11.
my lords, that's, please see the definition of threshold value, what it means, my lords. Under the rules, they have extracted, but please see the definition.
It is quoted here, limits
Yes, my lord.
described.
It
by
is
the
only
Indian
for the
Bureau.
purpose of that. Now, for bauxite threshold value is there. It is not for laterite. The problem
It
is
is a major mineral or not?
bauxite is a major mineral. Minor mineral laterite.
Therefore, it is be above 20%.
No,
In
my
the
lord, it is
guise
not
of
actually 20,
extracting,
above 20%.
extracting laterite, they want to extract bauxite and may.
And be like, it's not so simple, my lords, that we simply say it is like that.
They won't want to. Less. Something.
No,
They have already filed a counter.
Then case will counter the police.
Yeah, in one case filed, my lord, same thing is going to adopt in all the cases. Second matter.
Four men. And if your lordship sees their counter, they say we have not notified any threshold value for laterite. There can't be a threshold, my lords. Otherwise, for bauxite, you take a threshold value, that is only for bauxite.
Then if that argument is not to be accepted, the whole notification classifying this laterite as minor mineral, my lord, the basis for classifying this
Great respect.
a laterite as minor mineral is the threshold value.
My lords, with great respect, that's not how minerals are classified.
No,
Great
otherwise-
respect to my learned friend.
Council said that very
My lords, that's not how minerals are notified. It's depending on the mineral content.
Yes.
That's all, my lord. Threshold value.
Fixing of threshold value is a necessary consequence of classification of laterite.
Not only that, my lords, every mineral has the threshold value, which keeps, my lords, that's why, because of the mineral resources. My lords, they calculate the number, the total quantity available in the country based on the threshold value. How I can exploit it. That's the only purpose. The central government's counter, your lordship, kindly come to page para 2, my lords, it's at page 3, subject to correction. It starts on top. It is clarified. Yes, that's by the state government because it's a minor mineral.
Yes.
It's a rules, my lords.
Okay.
State government,
Page 84 is by LG.
central government.
It is government.
Yes, yes.
So there is some clash.
No, my lord. The, so far as the minor minerals are concerned, that in the parent act, that is MMDR Act, my lord, section 15 provides for rule making power. Under that rule making power, my lord, we have framed rule, yes.
To classify the mineral to minor.
No, central government classified. Your last may kindly take in that book only. Not page number 952, there is a notification.
It's a central government which classifies minerals, Ministry of Mines, major minerals and minor
Major
minerals.
minerals, lot,
When
it
it
has
comes to
been
minor minerals,
classified
the
by-
state has the power to frame rules. Now what they,
Ours is not Karnataka minor mineral rules, which are, these rules are framed under MMDR Act. Yes. Not minor, the not granting of lease or license in respect of minor minerals are concerned, it is vested with the state. State grants quarry lease, quarry license in respect of minor minerals. And it is empowered to collect royalty also. Yes.
That is done on the basis of this.
yes, threshold value.
Threshold.
Now, is it page 84? Would be your basis to levy the penalty?
Blood, it has been classic.
Page 84, IBM notification. Will it be the basis for you to levy the royalty?
Yes.
Or the schedule will be? What?
No, in schedule, we have to fix the price.
Will be levying royalty on the basis of the scheduled entry or IBM specifically?
Both, Milad, because IBM specifies this particular threshold, below this specified threshold value, this mineral is called as laterite, for which we have Milad fixed the rate.
% minimum is below threshold.
Minimum is 20%, Milad. Above that, it becomes bauxite.
No, that's not.
Below that, Milad, 20% is laterite.
That's with great respect. We are reading something which the central government itself does not say so.
Your last may kindly, further I have clarified this in para 13, please. Para 13, please. May I read, no? Page number 10. It is further submitted that Ministry of Mines Minister of Mines, Indian Bureau of Mines, with a notification dated 25th April 2018, reviewed the threshold value of minerals periodically under sub-rule 7 of Rule 12 of Mineral Conservation and Development Rules 2017. In the said notification, threshold value of minerals are tabulated. Serial number 2 pertains to bauxite mineral threshold value, so and so. Now we have read in page number 84. Under para 7A, threshold value of mineral will have meaning as defined in Mineral Evidence of Mineral Contents Rules 2015. Clause E defines cutoff grade, means the minimum economic assay grade of minerals for a deposit below which the mining operation become unviable in the present market dynamics or end-use quality. Further, Rule 8 of the notification mandates all the lessees are hereby directed to comply with the following. A, all resources shall be assessed up to the threshold value, and the resources between the threshold value and the cutoff grade shall be reported separately. There will, however, be no restriction in estimating resources below the threshold value if there is a ready market of such mineral or ore, either directly or after by beneficiation. B, non-saleable or unsaleable minerals, ores above the limit prescribed in the threshold value, and the below the cutoff grade shall be stocked separately in an area marked for the purpose. The inventory mineral or ore stock above the limit prescribed in the threshold value of minerals and below the cutoff grade shall be maintained in a bound register indicating quantity and quality of the mineral stocked. The overburden is etc. so and so. Further,
May I interfere, my lord, at this stage? Because I am in serial number 1, 2, 3, my lord. Here in the specific confusion that can be avoided is, in addition to MMDR Act, there are two more rules, that is MCD rules and MEME rules formulated under MMDR Act. Basically, section 4 to 14 of MMDR Act are excluded in respect of minor minerals are concerned. It is provided in section 13 itself. So herein, that only I will read one operator definition clause of MCD rules. Applicability of MCD rules is excluded for minor minerals. MCD rules cannot be taken out. And secondly, the section 2 application of MEMC rules.
MCD rule.
MCDR.
Rule number 2. Rule 2.
Expand ಮಾಡಿ rule. Abbreviation.
Mineral conservation and development rules.
Concession.
Mineral conservation and development rules, MCDR.
Yes, my lord. And notification has been issued under MEMC rules. That is total threshold value is totally excluded. I will be just reading that portion, my lords. Rule 2. Rule 2 of MEMC rules. MEMC rules. Page number ಇಲ್ಲಿ 336. Here is
that's the threshold value on it. Lords, these rules do not apply to minor minerals. Now, my lords, the central government's counter sets out the, what my learned friend for the state says. Central government says, we have not given any definition or any threshold value for laterite.
No, it's not.
So what we are trying
this
to
is
say.
applicable, my lord. This excludes fixing the threshold value. Threshold value cannot be prescribed in respect of minor minerals are concerned. It can be fixed only in respect of major minerals. Yes, my lord, that's what is, I have contained in my writ petition, that's why. No, that notification may kindly be seen, my lords. That is the notification which IBM has issued. Opening sentence it says, IBM, here in a letter so-and-so, is vested with the responsibility to review the threshold value of minerals periodically under sub-rule 7 of Rule 12 of Mineral Conservation and Development Rules 17. And threshold value is defined under MCD rules, MEMC rules. That is major mineral minerals. And I have contended in my writ petition, my lords, at page number. And another important aspect is, in order to say define a mineral as bauxite, it should contain more than 30% aluminous contents and less than 7% silica contents. In our case, it is not at all telling. Bauxite content is not 30% and silica content is, instead of 7%, it is 27%. By stretch of imagination, the mineral available in private pata land cannot be said to be bauxite.
Construction bricks, like bricks. It's usually found
or in
more
cement industry, even in cement industry.
as a component for
production
mix.
as a component. it
That
will be
depends.
used.
Cement, my lords, normally they go for bauxite. In case there is scarcity, they start using.
That is exactly for the reason, Lord, we have issued a notice to the clients of Kolle to produce where he has supplied this particular mineral, because we have assessed that they are supplying bauxite to the cement industry. They, instead of replying to that notice, Lord, they rushed to this honorable court.
Entry number.
The schedule itself permits that. Was before a single judge again regarding laterite and bauxite, there also Kerala High Court decided that laterite, there is no threshold value. There should be a clarification by the central government as to, because each mineral will have mineral contents. Its threshold value is a different concept altogether. That's for different purposes, threshold value.
The due respect. it is
Because
not-
unless you know what the mineral is, you can't say threshold value, I'll take that and say this is a laterite. That's not how it is done. That judgment is before me. And central government now says, I am not fixed for laterite.
The
That
rule
notification
applicable-
is not there.
The rule applicable in this case is Mineral Evidence and Mineral Contents Rules 2016, which defines blood threshold value of mineral, cutoff grade. Everything is defined under those.
Please
That
see
rule.
rule 2, my lords, in that. It says it is not applicable for minor minerals.
Yes, ma'am.
No, not that.
Yes.
Yes, same
Mineral
rule.
Evidence.
A learned friend, what rules he is referring is, let him see rule 2. It says it's not applicable to minor minerals.
And the learned central government educators also considered at
Not
page,
that.
para number 3 of their counter.
ನೀವು ರೂಲ್ ನೋಡಲ್ಲ, ನಿಮ್ಮ ಕೌಂಟರ್ ನೋಡಂಗಿಲ್ಲ, ಬುಕ್ ನೋಡಿ.
One single sentence, my lord. It's a counter, my lord.
ಇದೆ ತಗೊಳ್ಳಿ.
However, as contained in
Nodi.
para 8,
Rule 2 ನೋಡಿ.
the IBM has not notified or published any threshold value for the mineral laterite.
Right.
Laterite is
Schedule and even notification it,
When there is no
only
threshold,
my minimum 20%, now they are referring to.
that's for bauxite, my lords. There's totally difference between that.
if impurities of silica comes more than 7%, that cannot be called as bauxite, which cannot be used in aluminum industry at all.
Minor.
Only for
Yes.
box.
Yes.
Lords, with great respect, that is what central government's understanding is also. And that's the stand they have taken even before the Kerala High Court. Now the state is taking some other stand, my lords, with great respect, that may not be correct.
No, let him show him, Lord, in that judgment where it is stated. No, I have read the
See
judgment.
the rules, sir. I don't
Even
know.
in the rules, Lord, in minerals evidence of mineral contents rule 2015, it is applicable for minor mineral also.
Applicability node either.
Now I'll have to only take your lordships to the rules. If my learned friend, I show the rule, he says, the rule says these rules shall apply to all minerals except minor minerals. Now he says it applies. Now what can I do, my lords? The rules say so categorically.
We'll think it over.
So one more submission, my lords. In my cases, only one small submission.
Please.
There's one small submission at this juncture, my lords. In respect of all my 3 cases, I was a leaseholder, a license holder. In the first case, they are not the license holder, they are only applicants. That is the distinguishing factor, my lords.
Sir, anyway, once lordship and myself will go through the entire file. Any clarification is again we will relieve.
Please, my lord. Please, my lord.
I would only, my lords, the central government has to come out with a clarification actually in this.
They are given.
They are the
letter.
main,
Ah,
they only say we have not given it.
There is not, between, there is no dispute that the laterite is a minor mineral.
That's all.
Only issue is regarding notifying the laterite as a IBM. That is not available.
No, that's only on
Minimum 20% is given, is only for the box.
bauxite. That's for bauxite. That's, my lords, that's exactly what it means. Anyway, my lords, I will also try to find something else, but.
Below 20% is classified in the
As a
schedule
laterite.
as laterite.
If the central government says so, my lords, we will be more than happy if they say so. That's not their version.
Central government is like us.
My lords, ultimately the control of the entire mining is under section 2. It is with the central
And
government.
since
They are the authority, my
the
lord.
challenge to the schedule, my lord, it is for the state to answer.
Yes.
We just that we are trying to understand. We want a specific stand from you also.
Please.
So number 66, right, for the petition. Right, the petitioner, my lord, is a beneficiation plant. Carries out the beneficiation of the iron ore mineral. My lord, it converts as iron ore concentrate. My lord, the forest department, my lord, at the time of transporting the iron ore mineral from the mining lease to our factory premises, we obtain permits from the Department of Mines and Geology and also from the forest department. The forest department, my lord, started insisting that even for the final product, you have to obtain the second pass.
In order to save the time of this honorable court, my lord, we have suffered an order in the similar case.
It is
My lord, we have
covered by a
filed-
judgment of your lordship.
It is, and we have filed SLP before the
Which case, sir?
the same.
My lord, Annexure
Annexure G 148.
What you?
In the case of Bodhur Seth Sita versus state.
The order is at 169, my lord. 169 is the order operative of the order.
Against which blood we have preferred a SLP, which is pending before the Honorable Apex Court, which is pending consideration. No
Correct.
interim order has been granted. Subject to this blood,
Respondent, restrained from compelling the petitioner from second.
Same prayer.
Yes, same prayer has sought.
What about this page 170? Supreme Court is pending.
My lord,
Pending.
Supreme Court refused to grant interim order, my lord. This order stays.
Only pending, no interim. There are no interim.
subject to,
In terms of page 169.
subject to result of this.
Yes.
Right, SLP number, my lord. 13991 of 2020.
It is there, annexure H,
Annexure
170.
H, yes. Great.
But with rider that's subject to.
Subject to the orders of the Honorable Supreme Court.
Maybe pass.
Yes, yes, please.
Obliged.
Number 67, sumo to criminal contempt. Sixty-seven.
Request the Karnataka, the CGP to assist the. Not it. Notice. Government paid. HCGP Amicus will apart HCGP. Government paid. ಯಾರು ಇವ್ರು ಯಾರಿದ್ದಾರೆ ಹೆಸರು HCGP? ಇದರಲ್ಲಿ ಸೊ ಇದು ಅಮಿಕಸ್ ಆಗಿ
SPP tax in,
Mr. Anup Kumar. Mr. Anup Kumar.
Anup Kumar.
From the SPP office. SPP or office?
He is along with SPP.
No, special public prosecutor.
High Court government. ಅವ್ರ ಹೆಸರು ಹೇಳಿ
Anup Kumar, Mr. Anup. I shall inform.
Office in one set of copies.
18th April. 68, urgent, seal number 69.
Appear for the appellant.
My lord, I appear for the respondent number 1. So here there are two IAs. One is for the continuation of the delay. Another is for the stay of the operation of the order passed by the honorable and single judge. So my request is, I request your lords to give me some time to file objection on IA1 for the continuation of delay and also on 2. Because there is a deliberate delay in filing this.
In fact,
appeal.
I may submit that there is no delay as such, but the application has filed only as a measure of abundant precaution. From the date of the subsequent order passed by the learned single judge, appeal is filed within 30 days, within the period of limitation. As such, there is no limitation. But if we calculate the limitation from the date of the original order, yes, therefore, so therefore, I have filed the application for seeking condonation of delay.
Order may be a ground for condonation.
Yes.
And the counsel for the first respondent, seek time to file the counter to the IA1 of 20. Date. 2 weeks. 2 weeks, 3rd week, March,
26th March.
Well,
70, 71 urgent, seal number 72. Mr. Ashton, Nipan, party in
Lord,
person.
we have filed an appeal challenging the order disobeyed. Lord, that was filed on 9th of January. Lord, may I request that the writ appeal may be taken up along with this. It's numbered as writ appeal 59 of 2024. There were some office objections which, my lord, we have removed. It is under scrutiny. If I'd be grateful if your lordship could take up that, my lord, along with this petition.
Additional Solicitor General.
Lordship, no efforts have been made to clear the scrutiny.
PA number 59 of 2020.
And also, there is no stay of the learned single judge order. As such, the contempt of court case to be taken up, that is my request.
Same person is present. Post this contempt along with writ appeal 59/1.
This is a case since last 18 years, this is pending.
Since the
We are requesting this.
Additional Solicitor General is saying they have already filed the writ appeal, we will take up both writ appeal and contempt together, then we will take hear together and dispose of.
I'm grateful.
You take a date could you?
Date.
4th of April.
I'm grateful.
Number 73. Ishu Baba R. Mishra.
Lordship, sir. Lordship, this contempt is regarding to the order dated 7 July 2023, wherein the accused was directed by this honorable court to pay rupees 75 lakh towards permanent alimony towards the complainant. Within 3 months, failing which he would have to pay interest at
You
6%.
go for recovery proceedings. Contempt is not a execution proceedings for recovery.
But this honorable court itself had directed the accused. Lordships.
To pay 75, I will issue notice.
Regarding conjugal rights.
No, no, Your Lordships, it's regarding alimony. Page number 16, Your Lordships.
Why can't you go for execution before the family court?
But Lordships, order was passed by this honorable court.
You want the order of this court will be executed here only. You can go before the family court, Tumkur, sir. Go there and file execution petition along with this copy. And execute, and he is resident of Tumkur. She is the wife.
Yes, yes.
Five four. Number 74.
An order is passed by the magistrate.
23 now.
An order is passed by the magistrate under sections 14 of the Surface Act.
23 no, innೊಂದು connected 23 no ಇದೆಯಲ್ಲ sir.
ಹೌದು. My lords may take the 74 itself. No?
Yes.
Annexure A, order is passed by the magistrate. Pursuant to which, my lords, I take possession on second 74. I take possession on 2nd December 2023. That possession, Mahazar, is at page 662, volume 2. Court commissioner comes and takes possession and makes over the possession to me. That is inventory is at page 660. Then, my lords, 2 days thereafter, on 4th December 2023, writ petition is filed. 2 writ petitions, one by 13 persons, another by another batch of 13 persons, questioning order of the magistrate passed under section 14. On the same day, writ petitions are taken on board and notice is issued to both the respondents in the writ petition by hand summons to be served by the petitioner's counsel. And the court grants on the same day a restraint order not to take any coercive action. Then, my lords, I file statement of objections, which is at page 600. There is only unmaintainability I file saying that for any order passed under section 14, remedy is under section 17 of the Surface Act before the DRT. This writ petition cannot be entertained.
that objection is not answered. Learned single judge proceeds to allow the writ petition, holding that only a security interest which I secure from an assignment deed can be enforced. Whereas, my lords, I place on record at page 626, a joint mortgage is executed. That mortgage I place on record.
When a single judge entertained the petition for a, the issue goes to the root of the complaint.
Yes, my lords. And on the one thing that happened, my lords, on 14th of this month, the matter, 14th February, the matter came up before this honorable court. For want of time, the matter was adjourned to 26th. On 16th, my lords, they break open the locks, barge into the premises, and they are now squatting on the premises, which possession has been delivered to me by the court commissioner on 4th December 2023. Therefore, I have filed an application for a direction to the police to restore me the possession. That is for restoration of the possession. Police has to assist me. That is my. That is the IA for direction, police assistance.
Now you are in possession.
My lords, I have been delivered possession on 4th. They have breaking open the even very this one, what's the even time this kind. He does not answer the preliminary objection raised at all. And no time is given to me even to file on merits, anything. And my lords, it is actually taken up on a day-to-day life basis, like a criminal trial for murder of somebody. This is just, my lords, the.
Can answer on merits, but to make such allegations against the learned single judge would be incorrect. My learned friend did not appear.
No, I did not
With
appear, but I
great
have
respect, the other counsel was there. Because we were praying for the interim order, my lords, it was being taken up. There was no objection by the other side not to take up. Today to come here and say, and they took 1 day's time to come back. In spite of it, the learned single judge granted them more time. They engaged a senior counsel after the matter was being parted. Today to say single judge criminal trial on merits, yes. But to attack a single judge, my lords, on those grounds may not be correct. It's not right, my lords, with
I
great
have the
respect.
order sheet of the learned single judge. My lords may kindly have a look at the order sheet. Even the.
There was not a single prayer made. Counter they filed, they argued the matter. Today to say single judge did not give time.
Counter we have filed.
It is not
on
proper
maintenance.
on the appellant's part.
Those are the peripheral things. Now come to the point.
Yes.
Point is this much. Learned single judge gives a finding that the my lords would kindly take annexure A out of the learned single judge, which is at page 24 is the order. His reasoning, my lords, at para 3, page 34, he refers to a recovery certificate issued by the DRT in favor of the appellant in the year 2006. And what he notices as the submission of the petitioner is 45 crores 63 lakhs is the recovery certificate that is issued to me. Then, my lords, he refers to a deed of assignment dated 4/2/2008, executed in my favor by the lending bank. Next paragraph, my lords, he refers to that section 13(2) notice issued on 22/2/2000. My lords, I was made a party on behalf of all the lenders. All the lenders were not arrayed as respondents. That is my position, lords. I acted as leader of the consortium to initiate steps under section 30, under the Surface Act. Those authorities also have produced, those authorizations also I have produced at page 718 onwards.
The assigners said that the assignment was of 4 hectare and 2,000.
My lords, assignment is not necessary, my lords, because under section, the definition of security interest is, it includes mortgage and it is a wide definition, it is an inclusive definition. And in the meeting of all the lenders, I have been authorized at page 705. On behalf of on behalf of all the lenders. That is my lord, subsection 9 of section 13 and subsection 1 of section 10. They authorize me. He notices learned, the learned single judge notices section 10. Section 10 of the Act empowers Section 10 of the Act empowers an assessed reconstruction company to act as agent of lenders. Section 7. Other functions of asset reconstruction company. Any asset reconstruction company registered under section 3 may act an agent for any bank or financial institution for the purpose of recovering their dues from the borrower on payment of such fee or charges as may be mutually agreed upon. Then, my lords, may kindly see section 30, subsection 9 of section 13. Subject to the provisions of the Insolvency and Bankruptcy Code 2016, in the case of financing of a financial asset by more than one secured creditors or joint financing of a financial asset by secured creditors, no secured creditor shall be entitled to exercise any or all of the rights conferred upon him under or pursuant to subsection 4, unless exercise of such right is agreed upon with the secured creditors representing not less than 60% in value of the amount outstanding as on the record date, and such action shall be binding on all the secured creditors. Here, my lords, a joint mortgage is executed in favor of all the lenders, numbering about 8. That mortgage, my lords, deposit of title deeds is at page 626. Learned single judge omits to consider that document. At 626, memorandum of entry for extension. On the 11th day of July 1998, my lords may take para 2, my lords. They said so and so stated that the documents of title deeds and writing more particular first schedule hereunder in respect of companies immovable property situated at plot number so and so, Pina Industrial Estate, etc., etc. More particular, the second schedule written were deposited on 2nd April 85, further deposited by way of constructive deliveries on 17th October 88, 21st July 89, 16th August 89, 21st September 92, 29th September so and so, 20th this one, with KSFC and KSFC acting on itself and as an agent of KSIIDC, Industrial Finance Corporation, Canara Bank, ICICI, IRBI, Fuji Bank Limited, in order to create security by way of joint mortgage by deposit of title deeds on the company's immovable properties, both present and future. Thereafter, my lords, the meeting of at the 630 is the schedule of the property for that mortgage document, which clearly says 1 acre, 1 hectare, 2012 square meters. Then, my lords, at the page 660, my lords, the page 506. Prior to that, my lords, the page 506 is the notice issued under section 13(2). on 22/2/2016. This my lords refer, is para 2, it says, it started my lords para 1, we IARC acting in capacity of trustees, etc., etc. Hereby issue this notice to you, electrics, in the capacity of the borrower, mortgager, address mentioned above 13.13.2. Canara Bank, IIBI, United Western Bank merged with IDBI, Industrial Development Bank of India, Stressed Assets Stability Fund, since assigned to Kotak Mahindra, Bank of Maharashtra, SBI, Commercial and International Bank, etc., etc. Next page, Manoj. Collectively referred to as secured creditors. The secured creditor, at the request of the company, has internally extended time to time various credit facilities by way of financial assistance. Annexed and marked as Annexure A are the details of the debts due. Page 509, my lords, is the debts due to each of the lenders. It comes to 895 crores. Then, my lords, the particular of claim is a page 510. The particulars of claim is demanded of you in respect of all the financial assistance by the company, and as mentioned in Annexure C, in the event of non-payment of the amounts, IARC shall take steps for itself and on behalf of all the secured creditors for the enforcement of security interest with respect to the security assets described as in Annexure B, entirely at a risk, so and so. Then we also put them on notice. Kindly note that after the receipt of this notice, in terms of section 1313 of the Act, you shall not transfer by way of sale, lease, or otherwise any of the secured assets described in Annexure B here without the written consent of the approval. Please note that notice is issued under section 13(2). Then, my lords, at page 512, the amounts due to each of the lenders is catalogued. At page 514, security, that is immovable property, all that piece and parcel of industrial land with buildings, structures, fittings, fixtures thereon bearing plot number so and so, Bangalore, totally measuring extent of 1 hectare and 2012 square meters and bounded on the. Thereafter, he does not give any reply. The borrower does not give any reply. Then, my lords, Annexure K is the 13(4) possession notice issued on 2nd February 2015 under section 13(4). In fact, I have placed on record, my lords, the minutes of the meeting of the lenders. That is a page. Huh? Then, my lords, at 703, if my lords would kindly tell me. This is the proceedings of minutes of the joint meeting of all the secured creditors, which was held on 12th August 2011. Where this was held pursuant to letters of authority issued from 718 onwards. Then, my lord, there was some insolvency proceedings initiated by the company itself under the insolvency code. Then we had to wait till that concluded. Then, my lords, I file application Annexure P before the magistrate. Additional Chief Metropolitan Magistrate. That Annexure P application is at page 549. Learned single judge, my lords, extracts a part of this application which mentions about assignment deed in my favor. That is, my lords, of Eviction P application as noticed by the learned single judge. It is at paragraph 12 of the, it is at it is at page, internal page 20, running page 43 of the order of the single judge. Where he notices about the assignment deed in my favor, which is restricted to 2012 square meters. He does not refer to pages 552 and page 553, where security created in respect of all the borrowers is mentioned. And then almost renders an order saying that I could have proceeded against the borrower only to the extent of 2012 square meters and not 1 hectare, ignoring the fact that there is a giant mortgage deed whereby full property is charged in favor of 8 lenders, and says that nullifies my action. And he gives a finding, my lords. A security interest can be enforced only when it is backed by assignment deed. That is, my lords, the learned single judge finding is at paragraph page 26 of the order, my lords, internal page 26, running page 49. Therefore, enforcement of security interest as obtaining under section 3 of the Act, 13 of the Act can be at the hands of an assignee. In the case at hand, the bank, the assigner and the company, the assignment, the agreement between the two for transfer of rights is the assignment deed. The assignment deed by the assigner to the assignee nowhere mentions 1 hectare, 2012 square meters. It is only mentions 2012 square meters. If it is this act of the respondent company that merited entertainment of the petitions, as it was calling in question, an order of the learned magistrate which directs taking possession of 1 hectare, 2012 square meters. In the normal circumstance, the petition of the kind would not be entertainable, as there is apparent statutory aberration by the assignee, which is statutorily recognized. The petition has merited entertainment. This is the reason he gives for ignoring the statutory remedy. Even if it is, my lords, if that is the case, that is a matter to be told before the DRT. At least there are more than a dozen reported judgments which have said that for any security enforcement measure taken under section 13 of the Surface Act or any other provision, remedy is only before the DRT. And then, my lord, he proceeds to say that writ petition is allowed in part. The orders dated passed by the magistrate are set aside. First respondent is according to is predicted. Now, my lord, the
Assignment is only 2012 square meters.
assignment is
So 1 hectare
2012.
is concerned, only the issue is 1 hectare.
But the mortgage is in respect of 1 hectare, 2012 square meters. Now, kindly see the definition of security interest. Under section 2ZF, 900 crores, 900 crores. Section 1312 notice itself says 859 crores.
We are neither borrowers nor guarantors,
No,
nothing.
no,
We are not-
I have not taken any action against them.
They come into our property and lock it. That's our
Their
problem.
property, all of them, they, in the index of the writ petition itself,
OTS document
My lords, that is with the borrower, original borrower. My lords, the memo your lordships get.
it is between the original borrower and
He is not a bank.
We are not the borrowers.
Not
Against the borrower, let him go. We have no problem at all, but they can't come into our property.
they purchase
He's
the
an
property mortgage to the financial institution. Kindly see the index, my lords, in the covering sheet of the writ appeal. All their sale deeds, kindly see, what are their dates? Annexure J, my lords, Annexure J is the surface notice. That is dated 22nd February 2013. Then, my lords, the possession notice is 2/2/2015. Sale deeds, my lords, sale deeds start. First sale deed is 16th April 2021. Every sale deed is dated thereafter. Annexure B series in both the writ petitions are the sale deeds. What is the validity of the sale executed after the 13.2 and 13.4 actions are taken? Subsection 13 of section 13 statutorily voids those transfers. And they are in collusion with the borrower is clear because they have produced every document of the borrower. Yes, Rajagopal. Yes. Sridevi, assistant.
This. KN. KN.
Srikanth Patil K. K. Udayavallam. Udayavallam.
Rakesh Bhatt.
Rakesh Bhatt.
Rakesh Bhatt.
Please.
What is that? We have prepared one short synopsis, list of dates, just to assist your lordships. I've given.
Great. I would file 3 days, my lords. Before Thursday, it will be. We will file it, we hand it over to the court officer.
When both are connected, it's a common order. Let's.
Two appeals.
Two appeals. Two appeals.
Both writ petitions, identical writ petitions decided by a common order. Yes, sir, 13 purchasers, 13 purchases in each.
This keep is simple, my lord. One Here is added with, when it was only 2021.
Either it is added or removed. That's.
For us to state, it will be difficult.
My lords,
I know
we
that,
took
I
it
know
as a lighter, my lords, as your lordships indicated.
Please.
Great.
Notice Speaker Patil or Patil.
Would I accept notice for respond number 1 to 13?
Yes.
Lord, we will file the wakalat nama, my lord, in the office itself, my lord. Today itself, we will file the wakalat. Tomorrow, my lord, we will file the.
R 1 to 13, my lord, in writ appeal 231, I have filed wakalat, my lord. I accept notice, my lord, for respondent.
Please. R 1 to 4 and remaining respondents, my lord. Please, my lord. Please, my lord. I'll undertake to file the wakalat, my lord. By tomorrow morning, I'll file the wakalat. Please, my lord. All of them, all the, except, my lord, the borrower, that is respondent number 14. For all other respondents, my lord, I undertake to file the wakalat nama. Please, my lord. Please. Please, my lord.
My lords, there, the notice was not taken out because it's a borrower who is not concerned here.
No, no, there, my lord, Leonard Singhal, what happened was, Leonard Singhal judge directed notice to the borrower also and ordered that petitioner shall take handsome from them. Leonard Singhal judge does not record whether it was served on the borrower or not. The fact that the borrower is unrepresented.
Except the borrower. my lord.
Except the borrower.
Borrower who has disappeared, he was not represented even before.
$13. Please.
R14.
R14, my lords, he was directed notice, but there is no record of his having been served.
He could be dispensed. Original borrower.
It can be dispensed with, my lords. There is because he was not served in the writ petition. He was very well, man. Very well. He say he was not served in the writ petition, therefore. Very well. And that day memo also we filed. Very well. Please. My lords, could it be on Thursday, my lord? I have some difficulty tomorrow because I am not at Thursday, my lords. Yes, my lord.
Otherwise, we'll pass it on, my lords. Otherwise, we'll start again one more round of.
No. On Thursday, only for handing over. Yes, my lord. So Wednesday, it's very well.
Well, please.
Good. Case number 82,
Lords, the accused are directed to be present. Sorry. I'm Ravi Varma Kumar, senior advocate. Now, serial number 82, the accused were directed to be present to be heard before framing charge.
Lords, in serial
They are
number
present,
82, I appear for the state. Lords, in that review petition, my lords, is filed. Notice is issued. It is set down tomorrow, my lords, to be heard. We have served copies on the other side. So the learned single judge has in fact issued notice, my lords, on the review petition. It's listed tomorrow. So only 82, my lords, can be taken up next week based on what happens in the review, my
Now,
lords.
with great respect, this has been going on for the last 7 years. 3 undertakings were given. Today it
Notice-
is set down for
but
compliance.
Notice has been issued in review petition, which was on the last date review petition was just filed, my lords. Review is coming up tomorrow. Learned single judge has issued notice. They are to be heard tomorrow, my lords, and based on the review orders, next week, my lords, it may be taken up. 82, my lords.
Sir,
That's what
kindly
it is.
see the order sheet. The previous order is very clear. He had taken time to report compliance.
Lords, we have
It does
taken
not lie
and-
in their mouth to say, we are going to file an appeal or.
No, no. We have also
No, that
stated, my
period is
lords-
over.
No,
With
no.
great respect, that period is over. 3 times extension was given. That period is also over.
Lords, with all due respect,
We
on the
were
last date of hearing,
unnecessarily-
we had made a
we are
submission that we are filing review
unnecessarily
petition.
harassed.
Review has been filed and my lords, notice has been issued and it is set down tomorrow, my lords. On the last date, last 2 dates itself, we made a submission, review is filed. Kindly see the order sheet prior to that.
Sir,
1
the
week
writ-
is what we are saying. Please, my lords, please.
No, the writ petition, no, time for compliance itself is over 1 year ago. They have given an undertaking that they will observe us.
Please, 14.
My lords, 114. Serial number 89, my lord, kindly have it on 27th or 28th. I will inform the opposite counsel.
My lords, I appear for the appellant. My lords, any date next week, my lords, 27th is, my lords, a long date. My lords, it's a
I've
long
already
date, my
informed
lords,
the
any date
senior,
next
my
week.
lord, 27 or 28, my lord, I've informed their senior round. Grateful, my lord.
Serial number 75, next matter, it may taken up on next week, my lord. Serial number 75, next matter, it may kindly be taken up on next week, any day. Please, oblige. Please, please, please.